on the Zoom webinar, and I will let you know when we are live on YouTube. Madam Chair, we are live on YouTube.
Thank you. Well, good morning. We'll officially call the Senate Judiciary Committee meeting for January 20th, this Wednesday. Some of the new members of the Senate Judiciary Committee and some new LSO staff here who has agreed to help us. A warm Wednesday welcome to you on this great day where we have a full slate of work for us to get started on, but we'll go ahead and start with roll call.
Senator Cooper.
Here.
Senator French.
Here.
Senator Cole.
He's excused. I think he's having some technical difficulties.
Senator Cost.
Present.
Chairman Nethercott.
Here.
Madam Chair, you have a quorum.
Wonderful, thank you. As a reminder to the committee, we have a new Zoom platform, and so we have attendees who we anticipate to testify and public comment to us. Those attendees can see everything we're doing live on Zoom and hear and participate, and they can also watch the live stream on YouTube. And so that's where other members of the public who may not intend to provide public comment can follow along with our meeting. I would encourage you to remember to use your mute button when you're not intending to speak, and also turn your camera off if you need to take a break and step out. I do intend to take some breaks as we work through the morning. We have a 4-hour hard stop. So the meeting is starting at 8:30. So we are slated to go through until 12:30 this morning. As indicated from our agenda, we have a lot of bills to get through. Any bills that the committee is unable to get through this morning will move over into the full session in March when we will have the opportunity to work them then. So all is not lost for anything we are unable to get to today. So with that, we have new LSO staff, and just to have them introduce themselves to those watching live on YouTube as well. If we can have you guys pop online and introduce yourselves to the members of the public and to the committee as well.
Good morning, Madam Chair and committee, as well as the attendees. My name is Danielle Creech, and I'm a research analyst here at the LSO. I'll be helping out with the Judiciary Committee today. Thanks.
Thank you.
Good morning, Madam Chair and members of the committee. My name is Clarissa Nord, and I'm also a research analyst with LSO, and I'm happy to be helping out this morning. Thanks so much.
Well, we are thrilled to have you, and we are very grateful that you're here. We're in good hands knowing that you're ready and available to help out the good Senate Judiciary Committee. So with that, Senators, we'll dive into the work of the day, which is Senate File 5, Driving Under the Influence Amendments. Do we have some members of the public who are intending to participate on this bill here? It looks like we have maybe Senator Kobe, who was looking at coming in. We have the YDOT director, Mr. Reiner. Mr. Reiner, good to see you this morning.
Thank you, Madam Chair.
Is there anyone else with you that intends to testify on this bill?
Madam Chair, I would like to invite Lieutenant Colonel Ratliff, Mr. Rossetti, and Miss Misty Dobson to join us, if that'd be possible, as the experts on this bill.
Absolutely. Let's bring them on in.
Madam Chair, I do not see anyone other than Ms. Rossetti.
Well, we'll buy some time for them.
Absolutely, we'll work that behind the scenes, and when they show up, we'll ask you to let them in then, please. But we'll talk without them if you're okay with that, Madam Chair.
Absolutely. Good. So, Director Reiner, would you like to walk us through this bill?
Madam Chair, that I would be happy to do so. Let me just start then by as sort of an introduction. Luke Reiner, director of YDOT, and happy to be here, Madam Chair and members of the committee. So I'll tell you, just as a little bit of refresher for the new members on the team here, this bill is really a comprehensive review of our driving under the influence statutes, which really was an interim topic sponsored by your committee after some significant discussions on another bill last year. And certainly thank the chair and members of committee for working this issue during the interim. And we're very happy with this bill and what came out of it. Now, this bill affects WYDOT in really two ways. One is sort of on the backside and the housekeeping side of what we do with DUI is in terms of administrating driver's license and ensuring that that side works good. And then the other side is really the law enforcement side where this whole DUI process starts. And you'll see both of those issues in the bill. And as I walk you through the bill, my intent right now is sort of to keep it in terms of let's talk concepts because it will bounce us through the bill, but I think that might be a more effective way of just sort of keeping us on task as we go through here. So just as sort of an anticipation of what you'll hear in the bill is really this bill does three things for us. One, on the housekeeping side, it aligns the years in statute regarding penalties and other provisions, because just over the years, there's been amendments made and there's just unintentional mismatches that have occurred. And so this is a chance for us to police that up. And then the second thing that you'll see in here is the requirement for WYDOT to promulgate rules and regulations for how people who have lost their driving privileges for life can get them back. And we'll talk that when we get there, but those are the sort of two sort of housekeeping issues. And then the third issue, which really we see is absolutely critical, put some teeth into the law regarding the growing number of people that our law enforcement have seen who are refusing to submit to a chemical test after they're pulled over and arrested. And even with a search warrant, they're refusing the test and basically walking away. And that has caused a chilling effect on our law enforcement community relative to enforcing the DUI laws. And so those are the three areas that you'll see in the bill. And so Madam Chair, if you're ready, we'll just go ahead and jump into the bill. And if we'll just start, my recommendation for us would be to start. I'd really like, if you scan on page 1, section 1, 3631-6-109, it is a new section. And just because it's new, it's first. My recommendation, what I recommend to us is that we flip over actually to page 4 and start working the bill there. And I'll come back to the new section in terms of penalties. But if we start on page 4, line 7, 316-101, this starts the discussion of the refusal of individuals to allow blood to be drawn after they've been pulled over on suspicion of driving under the influence. So if you go to the, and these would be all amendments then to existing statute. So if you look at line 12, it adds 31-6-109, which is the very first new section that we started with, which we'll go back to. And then as you flip through over to page 5, it starts adding the discussion of a chemical test. So, but basically because we haven't talked this as a group, let me just say that just review a little bit what got us here. So the issue that brought this to the forefront is that law enforcement has really reported an increase in refusals to provide biological evidence. So that's blood or urine, even after a legal valid search warrant has been obtained, because existing statute says, hey, we can get a search warrant to pull your blood or your urine. But there's jurisdictions in Wyoming, not all, some, that do not allow a forced blood draw. And it has hindered prosecution, and it has often resulted in dismissals of a DUI charge. It's probably unintentional oversight of current legislation. I think everybody thought that a search warrant would result in obtaining the chemical test evidence, but really that has not been the case. Other things that came up in discussion over the interim, even if you use a physical restraint like a chair, that is considered a forced draw. So, and that can be done either at a medical or a detention center. Even if they're performed in a reasonable manner, they're considered a forced draw. Where are situations that prevented us from drawing these legal examples? The prosecutor might say, no, we don't do forced blood draws. The sheriff might say we don't do forced blood draws. The judge of the jurisdiction may say we aren't going to do it. And medical personnel may say we aren't going to do it. So at every level, there is some pushback on that. And so really what this bill does, it adds additional penalties that YDOT can institute if members refuse to submit to a chemical test. Madam Chair, with your permission, I'd like, just in terms of background, to ask Lieutenant Colonel Ratliff if I missed anything in sort of the explanation there, if you'd like to add anything. But keep it brief and short if you would there, sir, please.
Absolutely, Director. Welcome, Lieutenant Ratliff, if you'd introduce yourself to the committee, and feel free to supplement as you see fit.
Thank you, Madam Chair, and good morning. Shannon Ratliff, work for the Highway Patrol. Director, I think you eloquently hit everything on the head. We're again we're experiencing an inordinate amount of refusals that may or may not result in a conviction. More often than not, the prosecutors choose not to prosecute because they're missing that large chunk of evidence. And then, of course, that person gets away scot-free. There's not even the per se suspension attached that is prescribed by law. And it's continuing to gain popularity and gain momentum, not only in Wyoming, but we're hearing that the state south of us is experiencing these same issues, and they seem to be growing. Madam Chair, that would be all I would offer in addition to what the director's already said.
Okay, thank you very much, Lieutenant Colonel Ratliff. So for members of the committee and Madam Chair, based on what you just heard, the interim committee voted to really amend the statutes and to add in some new penalties. And so really, the penalties that you'll see in here, and we'll get to them here in the bill, is one is that if you refuse to submit to a chemical test, say, well, that's okay, but you lose your driving privileges for 90 days. And the department, as in us, are required to suspend their driver's license for 90 days. And so that's the penalty. That's one of the penalties for refusing to submit to the chemical testing. And then there's also actually that's a significant a penalty that was added. And so if you look to and then actually the other ones was added was some significant fines per event, and that's in a new section that was added. So if you go down to the bottom of page 5, then the First Amendment, based on what we talked about the problem and the recommended penalties then that were added to the bill, line 20 through 23 says, if a person under arrest refuses to submit to the chemical test, then they shall be advised of the penalties outlined in 316109, which is the new section that we added, and then the existing 317-128.0, which pertains to the suspension of the license. And then if you flip over to page number 6, and you look at line 4 through 6, this is where it talks about the suspension of your driver's license for 90 days. So right now the statute says if your blood alcohol concentration is 0.08 or higher, that's on line 2 through 4 on page 6, then you lose or you suspend your license for 90 days. What this amendment does, it adds line 4 through 6 that says if you refuse to submit to the chemical test, then your license is suspended for 90 days. So that's the change on the top of page 6. If you flip down to the bottom of page 6, then in line 18 through 21, it again adds the language of refusing to take a chemical test to the appropriate places in statute to allow for the penalties to apply. And the same is true if you flip the page to line 7, correction to page 7, line 2 through 5. So those are the changes to add the penalties that we just added in the current statute. Then, Madam Chairman, if you bounce back to page 1 on line 12, that is the new section that's added, 316-109, and it talks about again the penalties for refusing to submit to a chemical test. And what those add is on page 2, the entire, really line 1 through line 14, and it basically says, hey, listen, in addition to any jail sentence authorized by law, you may be fined not more than $750 for the first offense, $1,500 for the second, and $3,000 for the third. So between the 90-day suspension and the addition of these fines, it puts some teeth into this continuing refusal of individuals to not follow the law and submit to a chemical test. The other item that addresses that concept in this bill then jumps to page 9 in the bill, paragraph 317-128, line 6, starting line 6, and really going through the rest of that page and on to line 1 through 8 on line 10 is the addition of the penalties concerning the 90 days suspension for refusing to submit to the chemical test. Madam Chair, that's a quick look at what was added to the bill in terms of the issue of not submitting to a chemical test. And perhaps in the quest of time and just logic, we stop there and talk that discussion, and then we can get to really the housekeeping side of the house of aligning years and aligning penalties.
Thank you, Director Reiner. I think that makes a whole lot of sense. Questions from the committee right now? Senator French.
Yes, thank you, Madam Chair. To Mr. Reiner, I'm new to all this, so little clarification. So if an officer pulls over someone who they believe is driving impaired, and that person says, no, I'm not submitting to any test, can they still be forced to take that test? What triggers that? Or it's just these additional penalties of losing their driver's license for a set amount of time, and the fines based on recurring offenses? I mean, I'm a little confused there.
Director, if you can.
Madam Chair, thank you. Senator French, that's a good question. I'll tell you, and let me start, and Lieutenant Colonel Ratliff can jump in here because I've, thankfully never been sort of through this process on either side of the house. And but my understanding is this: if you get pulled over and you refuse to have a breathalyzer, and then we say, well, we'll get a search warrant, which the law provides us to do, to have a forced draw of your blood, which is currently in statute. So we can force you to have your blood drawn. However, and that's through the search warrant process. However, what we're seeing is refusal of the system to conduct those search warrants, all right, at every level, whether it's medical or law enforcement or judiciary in certain areas of the state. And so in this case, the law is currently written in statute is not being followed. And so that's an issue for everybody involved. And what it was causing was multiple offenders who would get pulled over, basically refusing to have the test. And without evidence, there was really no prosecution and no conviction. And we would see these people again and again and again. And so what this bill does is recognizes that problem and imposes basically penalties outside of that forced draw system. So what you say, hey, basically, okay, the system's not going to draw your blood. And that's not across the state, but it's certainly in some areas. And we recognize that. And so here's some additional penalties. You're going to lose your license for 90 days if you don't follow the law, and there will be increased fiscal financial penalties on you. And so that is the workaround.
Any follow-up, Senator French? Okay, Senator Cooper.
Are there repercussions with the insurance companies for a refusal rather than a DUI? Can you explain how that's going to work for us?
Director?
Yeah, Madam Chairman, Senator Cooper, that's a good question. I think I know the answer to. Let me see if Colonel Ratliff can make sure that maybe he would answer that for me.
Colonel Ratliff?
Madam Chair, thanks. There are you and I believe whether or not you take the test or refuse to take the test, you're still going to go on high risk insurance. So the name of the form escapes me, but you'll go on high risk insurance for I believe a period of 3 years.
Follow up, Senator Cooper.
That's if you're with the bill as it's being amended. I can see that a refusal would show up. But right now, what happens if they refuse? They just walk? Is that what you're telling us? Some of them.
Colonel.
Madam Chair, thank you. And Senator Cooper, they do, however, and you're speaking in the context of the high risk insurance. I believe they do. I believe they walk.
Any other questions from the committee at this point? All right, committee, we're going to move on. Director, if you want to walk us through the rest of those kind of housekeeping items.
Thank you, Madam Chair. So let's switch back then to the bottom of page 2. And we'll go into starting in line 21. The discussion is section 31.5-233, which is a section about some of the other penalties and the backroom housekeeping for driving under the influence. And so if you flip over to page 3, line 12, actually starting on line 11, it crosses off 2 years and it puts in 3 years. And that's one of the mismatches that was in current law. And what this does is it changes this section to match the requirements in 31.7-127 sublegs Bravo. And so it aligns the years for in relative to how long you have to be on the interlock device. And that was the agreement we came to in the interim, is that we follow the requirements of 31.7-127 to be consistent. It doesn't change anything about the rules except aligning how many years in statute. And then if you flip down to line 21 on page 3, it adds in the words "and shall provide notice to the department." And this has to do with the issue of this whole paragraph is for a fourth and subsequent conviction. Basically, you lose your license for your life. However, in statute, in this paragraph, it allows the offender to appeal after 5 years to get his license back. And it does happen, all right, because people change the way of their life, and the law recognizes that. And however, what was happening is that appeal was being made, and this department did not know about it, and so we had a mismatch. And so what this addition allows is, or requires, is that this department knows, since we track the interlocker device that you have to have for life there, is we know that the appeal has been made and can start tracking. And then if you flip over to page 4, line 3 through 5, basically that requires the department to promulgate rules for the administration of the paragraph above. And that all has to do with the process to appeal after 5 years to get your license back, which has been suspended for life. And while the statute says you may, the details on how you do that are not specifically lined out. For example, what court do you go to? What's the definition of good cause? Because the statute says, hey, for good cause, we'll give it to, well, what's good cause? And then who receives notice and how that process works. So those are the rules and regulations. Those are the rules for the administration of the paragraph that would anticipate to be promulgated, and you require us to do that. So that's what's added there on page 4. So then if you flip over then, as we keep going through the bill here, we flip to page 8, we get into administrative hearings. And the change there is actually on page 9, line 1. And it says within, it changes 5-year to 10-year. And again, that aligns with current statute and makes it consistent. We've already talked about the changes on the bottom of page 9. And then if we carry on to the last section that is here in the bill, it talks about driving while your license is canceled, suspended, or revoked. And in this case, the change is on page 11, lines 3 through 11, and it deals with the issue of those under 21. And basically those lines are crossed off and everybody's treated the same. Madam Chair, with your permission, let me ask Mr. Rossetti or Ms. Dobson. Actually, I see Mr. Rossetti is on to just clarify anything that I might have missed in the discussion. And
Absolutely, welcome. Please introduce yourself to the committee and feel free to supplement as needed.
Good morning, Madam Chairman. My name is Misty Dobson. I'm the Program Manager for Driver Services. I believe Director Reiner hit everything on the head. A lot of the statute cleanup that we're looking at Driver Services is realistically, like he mentioned, aligning some of the things that have happened over the past and making sure that those periods are in sync. Perfect example of that is for that third DUI, when you're looking at a 3-year revocation of your license, but only a 2-year interlock requirement. Oftentimes people remove that interlock device after the 2-year requirement and then subsequently go back under suspension because they're not in compliance at that point. So it's very confusing to our clients. It's very confusing to the citizens of Wyoming. And it's just really important that we clean up a lot of that statute stuff out there.
Thank you, Ms. Dobson. Mr. Rossetti?
Madam Chair, I believe that Luke covered it. I just stand for questions if you have any.
Thank you, Mr. Rossetti. Committee questions? All right, seeing none. Thank you, Director and team. We appreciate you being here this morning, walking us through that bill. Is there any other public comments on this bill? Raise your hand if you intend to provide public comment. Looks like we have Mr. Adrians. Mr. Adrians, welcome. If you could show your video. And please introduce yourself to the committee and welcome.
Thank you. My name is Rich Adrians. I'm the facilitator for the Governor's Council on Impaired Driving. If you're not familiar with the council, it was a council created about 10 years ago through executive order by the governor. We're made up of over 30 folks that mission is to reduce impaired driving, especially injuries and deaths. We've got all walks, including public defenders, judges, prosecutors, law enforcement, concerned citizens, victims of DUI. And I just really would just like to make a comment that this was one of the issues, the BAC refusal test is one of the issues that made our strategic plan for 21 through 23. One of the strategies in there was to approach legislators to try to pass this. We've also taken other steps. I think this problem is most apparent in smaller jurisdictions or jurisdictions that are not staffed significantly. When I'm the recently retired chief of Sheridan, the city of Sheridan, and we have enough folks here that when we have a DUI and we need to physically take that blood from someone, there's enough people to get that job done through a chair. And even with all the resources that we have here, we still get about 3 a year that are just too violent to risk taking blood from them. So that's what the issue is. I fully support what's going on here. The councils obviously chose it as one of the strategies to move forward with, and I would just leave that comment and stand for any questions from the committee. Thank you, Madam.
Mr. Adrians, thanks for being here. Appreciate you having you take the time. Looks like Senator Kolb has a question. Senator Kolb.
Thank you. The question I have is the blood draw issue with the medical community. I found out when I was a county commissioner that some of the folks that in the medical field refused to do a blood draw because they felt like that jeopardized the life of their patient. And I mean, it was a terrible situation with death. And they flew them away on a life flight helicopter. And we had lost that ability, I believe, to prosecute because we lost that evidence. Is there anything we're doing to try to combat that or to try to come to terms with the medical community on getting that blood evidence? Thank you.
Mr. Adrian, if you know.
Madam Chair, Senator Kolb, absolutely. You know, it's all about relationships in your community when it comes to that. And what you're speaking to on those serious injury and death cases, that's been in statute a long time that we could get blood evidence in those cases. It's basically an education issue with the medical community. Where we're running into issues with, and why this legislation has been requested, is that in the less serious cases, it seems to be a more moral issue with the medical community. In Sheridan, we kind of chose, we don't like to bring forward folks that are already demonstrated that they're not cooperative into a more of a public environment. So, you know, we take care of this issue in the police building, which is attached right to the jail, a special room set up for this. So that's one of those issues. So most of the time in my experience is when it's those serious injury or death cases, we've been able to obtain blood. Many times the suspect's injured and we're able to get it through medical records after the fact.
Thank you, Mr. Adrians. Any follow-up, Senator Kolb?
No, I think that, you know, the issue is the, you know, the people doing the blood draw believe that the patient's cardiovascular system cannot handle a blood draw, and then they go out of state. And I guess I thought that was wrong, of course, that we didn't get evidence in the case of basically the driver in this case survived, the passenger had died, and we couldn't get evidence to that. And I feel like that's a shame, and we should try to rectify that situation. But thank you for answering the question. Thank you, Madam Chair.
Thank you, Senator. Any additional questions for Mr. Adrians? All right, committee, seeing none, is there further public comment on this bill? Or raise your hand if you'd like to provide public comment. All right, seeing none, public comment is closed. Committee, what's your pleasure?
Move the bill.
Moved by Senator Cost. Is there a second?
Second.
All right, seconded by Senator Kolb. Mr. Adrians, we're going to ask you to leave the meeting now that we're back to the committee. All right. Senator Cooper, are you there? All right, I'm sure he's listening in. Committee, any amendments to this bill? Seeing none, we'll take a roll call vote on the bill.
Madam Chair, this is a roll call vote on Senate File 5. Senator Cooper.
Aye.
Senator French.
Aye.
Senator Kolb.
Aye.
Senator Cost.
Aye.
Chairman Nethercott.
Aye.
That bill passes.
Thank you. And with that, we'll have Senator French present this bill on the floor. Senator French, a piece of a tip or advice is to reach out to Director Reiner potentially and ask for any kind of maybe additional information to help you explain it. And that's always a good tip and trick to do. And your committee will be there to support you as you present the bill on the floor as well. Thank you, Senator French.
Will do.
The second bill for our agenda is Senate File 21, Judicial Review of Agency Actions, Permissible Venues. Committee, is everyone familiar with? I think we've gone through a little bit of training just to make sure able to follow along with the actual bill version that has page numbers and line numbers on it, and you know where to find that online? Everyone's comfortable with that? Okay, good. All right, Senate File 21. Senator Cost, do you remember this bill?
Yes, ma'am. I even took notes last night so that you wouldn't beat me up too badly. So.
Good preventative measure. Or why don't you walk us through this bill, Senator Cost?
Okay, thank you. Madam Chair, the bill is Senate File 21, Judicial Review of Agency Actions, Permissible Venues, and it's an act relating to administrative procedure, amending the permissible district courts where judicial review for agency actions may be sought, specifying applicability and provide for an effective date. Basically, what we're doing in this is if you go down through the judicial review actions, there's a change on page 2 in the red on lines 4 through 6 that has put in entitled to judicial review in the district court for the county in which the injury or harm for which relief is sought occurred. You'll notice that down below there it says in the district court for the county in which the administrative actions or inaction was taken, or in which any real property affected by the administrative action or inaction is located. The missing part was where this took place. And so this is the insertion of that to make that correct. And if you follow through on down, we get to the effective date as July 1st of 2021. Everything else is standard to the bill. So I guess that's a quick and short summary of it. If there's any questions, I'd be happy to try to answer those.
Committee, any questions of Senator Cost? Senator French.
Yeah, what is, having not been in these discussions for however many months prior to getting to today, what is this trying to correct?
Great question. So what the committee may remember is one of our interim topics from the Judiciary Committee for the number of past few years is to review Wyoming Supreme Court opinions as they come out, where the Wyoming Supreme Court may mention the need for legislative action. And so this bill draft comes from that work of our LSO staff reviewing the previous year's Wyoming Supreme Court opinions. And this was a case where a litigant was denied the ability to appeal their case because the lawyer filed the appeal in the wrong county. And so no justice was able to be achieved as a result of filing the appeal in the wrong county, which really isn't the result that we're seeking. And this bill draft seeks to remedy that and allows for an appeal to take place in the district court where the injury actually took place, and likely where the litigant or the person or the Wyoming citizen actually resides with their lawyer. This is consistent with other types of causes of action. So if a person wanted to sue or needed judicial relief, they would sue in that county, typically where that injury took place. And there's a couple of other venue options available to them. But it looks like we had an error in our law that didn't allow for the appeal to be filed in this district court. And so really a harsh result that doesn't effectuate justice. And so the committee chose to respond to that Supreme Court opinion where the case wasn't allowed to be reviewed based on its merits, and instead dismissed outright on what would be a procedural technicality. And so we wanted to remedy that, and that's what this bill draft does. It won't affect that poor litigant or attorney who suffered that harsh result, but in the future it will prevent that from happening. Senator Cooper, question?
No, ma'am.
All right, is there any public comment on this bill? If so, please raise your hand. And I don't know that there would be. So seeing that there is no public comment is closed. So back to the committee. Committee, what is your pleasure?
Move the bill.
Moved by Senator Cost. Is there a second? Seconded by Senator French. I'm assuming there's no amendments, but if so, raise your hand. Seeing no amendments, we'll do a roll call vote on the bill.
Madam Chairman, this is a roll call vote on Senate File 21. Senator Cooper,
Aye.
Senator French,
Aye.
Senator Cole,
Aye.
Senator Cost,
Aye.
Chairman Nethercott.
Aye.
That passes.
All right. Thank you, committee. Good work. I thought we could get through that pretty expeditiously. So we are on time and under budget. Just a word for procedure. Some of the committees you may participate in don't require a second for these local committee meetings. It's my practice to require a second. Most of the committees do, and I think it's easier just to follow what is customarily done in most committees is to require a second. I think it's helpful. So just a point of clarification there. And so with that, we are on Senate File 22, electronic court filings. I'll explain the purpose of this bill to give Senator Cost a break. I do think that we have some public comment on the bill that we'll start adding in now. But Senate File 22 stems from the need for the Wyoming courts, the district courts, to be able to allow for filings of legal documents, otherwise known as pleadings, through email or electronic transmission. Currently, the law or the rules allow for, obviously, the use of hand delivery to the courts, the filing through the mail system, and also fax machines, but it does not address the need for email filings. So curiously, and like so many other things that we've experienced in the state and across the country, when the pandemic hit, our court system responded with flexibility and nimbleness and wanted to make sure they would remain accessible while ensuring safety procedures were met. And so they created some temporary emergency rules that allowed for the filings of court documents with email, with certain requirements that are typically associated with other types of court filings that could be filed with the district court clerks. This bill seeks to formally codify that allowance and turn it into a permanent rule, allowing for attorneys and pro se litigants to be able to file legal documents with the court clerk through email, through the procedures outlined here. As a word of kind of history and understanding the process of the bill, this bill was heard by the committee in May, and I believe in June, when the Joint Judiciary Committee formally adopted it. Since that time, the Wyoming Supreme Court and the district court clerks have adopted an additional rule, of which I believe they would prefer that the committee just honored and allowed to take place and not move this legislation forward. Of note, that rule does allow for the submission of email legal documents to be filed, but there are certain and additional stipulations associated with that, notably $1 per page filing fee cost. And so a notable difference between the two bills, and of course that one is a rule, whereas this would be law. And so a very important difference associated with that. Committee, I'll stand for any questions you might have concerning this concept or this bill. Senator French.
Yeah, Madam Chair. I know the clerks of district court don't like this. Can you expand on that a little more? I mean, I know, and trust me, I'm not a tech person, but I understand the need for continually updating, what you're doing. Because it seems like they're very opposed to it. So if you could help me out a little bit here.
Yeah, thank you, Senator French. I do think that's an accurate reflection of the district court clerk's positions, at least the majority of them, that they are against the legislation. My understanding from the testimony provided during the interim, and hopefully there's some that might be present here moving forward that we can hear from too, is that they're resistant to it primarily because it provides an additional challenge associated with the processing of the paperwork coming in, a new avenue for them to be receiving files or court documents to be filed. And that's challenging. I think they expressed concern about the cumbersome nature about an electronic submission like an email filing, wherein they have to print the document, open it, print it, physically stamp it, and then scan it back in. And that is cumbersome and requires time and workforce and cost associated with printing and ink and those particular logistics associated with that email filing. So that is I think I'm accurately reflecting the testimony that I heard in the interim and those concerns. I'm hopeful we'll hear from some others this morning that may be able to expound on that explanation, and you can ask them questions directly. But that's primarily the testimony we did hear. Senator Cost, do you remember hearing anything differently?
Thank you, Madam Chair. You know, I really don't. It just seems like they had a procedure down and that's what they wanted to follow. I think there's solutions to some of the things that they were opposed to, but I understand what they're saying as well.
All right, any additional questions? Senator Cooper.
Is there electronic alternatives to the stamp situation that can be addressed rather than having to print, stamp, and rescan? Is there a more technical method of doing that?
Yeah, Senator Cooper, I believe that there is technology out there where you can place an electronic stamp on a document without the need to print. I think our court system still operates in such a way that they have both an electronic system on their file, on their computer systems, and then also a physical file, and sometimes multiple forms of a physical file, including confidential versions of the same file. And so we have a pretty robust process, and I think that probably is a reflective of the time in transition that the court system is, of going from a historical way of doing things of all paper, predominantly paper, to transitioning into a digital version. There is an effort underway for a robust and comprehensive electronic filing system where all of our filing would be done through a complete electronic filing system where the court record would be accessible on the internet and by the public potentially. And that is underway. It's been underway for a very long time and continues to be underway for a very long time in the future. But one of the criticisms and rejections of this particular legislation is, whoa, we're working on a complete comprehensive e-filing system, and this is unnecessary because that comprehensive electronic filing system will be underway. But the testimony that I've heard about when that full comprehensive system may be up and operational and in a meaningful way, we're still years out. And so that doesn't do anything for today or next year or even the following year. I think we're going to be quite a ways out still, even under the best of circumstances. Senator Kolb.
Thank you, Madam Chair. Just how many documents a day are handled as an average throughout the whole year? I mean, I don't want to know about the day where there's a lot of folks come in, but the average amount of documents, does anyone have an idea on that number? Thank you, Madam Chair.
Thank you, Senator Kolb. I do believe that question was asked in the interim. I don't recall the answer, and that's very court specific. So, for example, the Laramie County District Court has a much higher volume than the Crook County District Court, just as a result of population. So those will vary drastically based on those jurisdictional differences. And I do think we have Ms. Lindenthal here, who I would welcome to the committee to provide some public comment and maybe answer some of these questions at this time. Ms. Lindenthal, welcome. If you want to introduce yourself to the committee and share your thoughts on this bill.
Certainly. Thank you, Madam Chair. My name is Patra Lindenthal. I'm the Clerk of District Court in Park County. Serena Lip is our president of the Clerks Association. She was swamped today, so asked me to step in, which I have no problem doing. So thank you very much. I guess what has been stated is correct. I don't know if the clerks are highly opposed to this. We just feel it's unnecessary due to the fact that the Supreme Court has amended these rules, rules 4 and 5 and 39, and also rule 203, which allows that's regarding the funding, paying for the fees. We just feel it's unnecessary at this point in time. Are there any questions? I don't know what questions you might have. I think Senator Nethercott was correct in that the number of e-filing documents varies per county. And certainly when the COVID initially began, we had substantially more e-filing than we do currently. Currently, maybe we have 5 a week. So the number has decreased drastically. So.
And thank you, Clerk Lindenthal. Can you maybe provide your best estimate as to how many filings you get per day, regardless of how it's received?
We're considered a medium-sized county, and I would guess between walk-in and mail, I'm going to say we get between 15 and 20 a day.
And approximately how many pages would you say each of those is? So recognizing
yeah. Some are 1 page. It might be just a matter of a setting getting filed or request for setting, or those are 2 pages typically. Now that we've gone to letter-sized paper, a 1 page now has become 2, and a 2 page has become 3. But I'm going to typically maybe 5, 6 pages, unless of course it's a brief or a memorandum or something like that. And then you're talking 20, 40 pages. It's hard to say. Depends on the document, depends on the attorney. Some are more wordy than others. So it's hard to say. Truly, it's hard to put a number. And like you said, Laramie County has way more filings and cases than we do here in Park County.
Well, thank you, Clerk Lindenthal. Do you have a sense for when the comprehensive electronic filing system will be up and operational for both litigants and the public to access?
I truly don't. I see that Lily Sharp is on the call. She would be better to answer that. We certainly, the Clerks Association certainly have some skin in that game, but I get the feeling it might be a couple years, but I hate to say that 100%. So if Lily could answer that would probably be more prudent.
Wonderful. We'll get to that question here in a minute. And one more question for you, Clerk Lindenthal. There's that $1 per page fee assessed for each of those filings. Can you explain maybe the rationale behind that $1?
Historically, electronic transmission of documents meant a fax filing. And we did get fax filings if there was a deadline that had to be met, or for whatever reason, we would accept fax filings with a phone call first, and then payment received and the original mailed within 24 hours. There was never an issue with that. Then when all of this change came about due to COVID-19, I believe, more and more, the courthouses were closed, offices were closed. So more and more attorneys started emailing documents. And since the Supreme Court had strongly urged attorneys to use email, they had asked that those fees be waived. And I agree with that. You can't ask on one hand to do something and then on the other hand charge them to do that. I don't believe all the clerks had that similar feeling, but in talking about it within my office and surrounding counties, it just seemed reasonable. Also, as you probably all notice, the mail system is so unreliable that a lot of attorneys will choose email over snail mail now because things just don't show up, or I mean, we have found that to be true, and things don't get where they're supposed to go. So I think that is part of the reason for the charging for the, and effective with the amended order, December 7th, I believe all the clerks started charging for emails as the same as fax filing. So, and it's just to offset the cost of printing the document from, because the county's using their own ink, their own paper, et cetera, and then shooting back the first page, or at least I think the majority of us do that. They'll shoot back the first page, but not charge for that.
All right, thank you, Clerk Lindenthal. Very
Sure.
helpful. Any questions for Clerk Lindenthal? Senator French.
Yeah, Madam Chair. Patra,
Uh-huh.
does this bill cost your department money? Is there an additional cost or a reduction in cost, or?
No, from what I'm seeing, it's just duplicating really the amended order that is in place. I don't feel that this, unless there's some legal reason that I don't understand, I don't feel that it's necessary, because this is covered in the amended Rule 5. Go ahead.
I'm sorry to interrupt you. Does it take your staff more time to do the electronic? I mean, do you have more staff hours involved in it?
No, Chairman Nethercott, or Chairman Nethercott, I'm sorry, Mr. French, or Senator French, sorry. No, I think the time issue is irrelevant, because we handle the paper no matter if it comes in the mail. The only thing maybe additionally is file stamping that first page and scanning it back to whomever sent it. But that's minimal, it takes me 30 seconds to scan and send a document, or first page of a document. So I don't think time-wise, the only cost to the counties, of course, is we print off the email. So we're using county paper, county laser ink, however it's the cartridge, or however, so there is that cost to the counties, but we're not using envelopes to mail back that file stamp document. So it might be a wash. I don't know.
Any follow-up, Senator French? All right, Senator Cost.
Thank you, Madam Chair. Ms. Lindenthal, a couple questions for you. If you were able to secure an electronic stamp so you wouldn't have to print it out, stamp it, and then scan it back in, would there be a way that you could have files for each of the documents so that they're kept on files in your storage? You've got, I'm sure that you guys have some kind of storage database to save any printing at all until it was necessary. I'm just wondering if there's a way that, with the financial situation of our state and all, if we could find ways to kind of reduce costs and some things. And I was wondering if electronically, if you could store those rather than having to print them out, and then also electronic stamp for the verification of it from your county office. Does that make sense, or is that ridiculous?
Certainly, no, it does. It does, Madam Chair, Senator Cost, that makes a lot of sense. And I think that's the ultimate goal for the e-filing. I don't have any idea what the software would cost or hardware would cost for something like that. Again, I think that's something maybe Lily Sharp could answer better. But certainly, I think that is the goal ultimately of e-filing. I will add though, the Supreme Court does receive e-filing, but they also receive the paper. So I think that getting rid of the paper itself is quite a ways down the road, but having it all on the database, everything on the database, and not having to print something out, I do think that's kind of the way it's going. So
Thank
thank
you.
you.
Thank you, Clerk Lindenthal. Any final questions for Clerk Lindenthal? Senator Kolb.
Thank you, Madam Chair. Good morning. And
morning.
I'd like to ask, I haven't heard yet the justification for the cost of $1. I think it's, I'm I'm confused because my past experience has said that paper should cost about 10 cents a sheet, is what I know about copying costs. I mean, I realize, there's a lot of questions here and it's new. And of course, most folks shy away from new. But in the day and age we live in, with the COVID-19 or whatever, COVID-20 or whatever else we're going to have coming up, and the fact that our mail service has become frankly unreliable, and certainly the timing can't be judged correctly, and the time-sensitive documents aren't, there's problems with them getting there. So, and then on top of that, we also have a backup email system that I think, and frankly, is more secure than paper ever was, because you should have offsite servers. I'm assuming that, Sweetwater does. So I think we have a situation in this day and age that we're forced to deal with, and I understand that my clerk in Sweetwater is not happy either, just to be clear. But we live in a day and age that we have to address the reality. And I think the $1 a page issue is holding back the use of the system that could be used, that could be more commonly used. And I've never heard of it costing actually $1 a page. And I think that for me, I haven't heard a justification. I'm open to hearing why it's $1 a page. I mean, if you can please, I guess, help me out with that, I'd appreciate it. And I guess that concludes my comments. Thank you, Madam Chair and Patricia.
Clerk Lindenthal, any follow-up?
Yes, thank you, Senator, Madam Chair. The $1 page is, the counties are struggling financially. All the counties are, and $1 page is just reminiscent and in line with what we charged with fax filing, because the county provided the hardware, the paper, the ink, et cetera. Same thing I think applies with emails. The county's providing the printer, the paper, the ink. It's just trying to offset the cost of those items within the counties.
All right, thank you, Clerk. With that, we'll turn to, sorry, Senator Cooper, please go ahead.
Clerk Lindenthal, thank you. You referred to amended Rule 5, and this being redundant.
Yes.
Can you explain a little bit about amended Rule 5, and does it sunset on us, or how long is that in force, or can you elaborate on that a little bit, please? Thank you.
Certainly. Thank you, Chair Nethercott, Senator Cooper. Amended Rule 5 addresses emailing and added some language. I presume you had not seen this, but it was allowing for emailing documents that typically wouldn't be emailed before, other than initial pleadings. Anything that required an affidavit, a notary, could be emailed. when typically those items would have been mailed previously or brought into the office. Prior to the pandemic, we had very few things come by fax. Attorneys here locally would walk in with documents, and it's just changed the scenery, I guess. The amended rule allows for attorneys to email, and then the original is not required to be mailed. So that saves postage at their end. They haven't had to pay for postage, pay for an envelope, but they have to retain that original in their file in case the judge or opposing counsel ever wants to see that original document, originally signed document, then it was readily available. So it just somewhat changed the way fax filing worked, is all Rule 5 did regarding filing documents.
Okay, it doesn't automatically repeal at any time because it was this a temporary thing?
No, to my understanding, and again, Lily maybe can better answer this, but to my understanding, this is a new order, district court order, until another order is made to repeal this, I guess, or get rid of it.
All right, thank you, Clerk Lindenthal. I think we're hearing a lot of comments from Ms. Sharp, maybe to come forward and maybe answer some of those questions. Ms. Sharp, welcome back to the Judiciary Committee, a frequent place for our committee. If you introduce yourself to our new members, it's great to see you, and we look forward to hearing from you.
Sure, I'd be happy to. My name is Lily Sharp. I'm the state court administrator, so I work for the Supreme Court, but I help administer all the courts throughout the state. And just for those of you who are new, we have 3 levels of courts. We have the limited jurisdiction courts, and that's our circuit courts. And then we have the general jurisdiction courts, that's our district courts. And then we have the Supreme Court. And as Clerk Lindenthal said, the Supreme Court has had electronic filing, that is where you file your documents electronically, since 2008. The district courts and circuit courts have been, Chairman Nethercott was right, that we had a false start in getting electronic filing of documents in the circuit and district courts. And just a bit of background, what actually happens, the way filing works in courts, in the trial courts, is, and actually in the Supreme Court too, is you first have a case management system. That's basically your banking system. It's the system that keeps track. It's also your document management system. And so that, and then on top of those systems, and let me tell you that. So the banking system, the circuit courts, they actually collect about $31 million of fees biannually, and all those fees, most of them, go to your school, your local school funds. The district courts don't collect as many, but their fees go to the counties. So just so you know, these fees, if you choose not to, well, let me go back. So these fees are, the Supreme Court has authority by statute, it's 5-2-202, to collect fees, and then, but it's up to you all to decide where those fees go, and that's by appropriation or by statute. So the district court fees go to the counties, the circuit court fees in non-criminal cases, and it depends on the type of case, but their fees go to the these filing fees go to the general fund, and then for you to appropriate. So whether or not the fee is collected, we don't really have control over it. But what we have is this case management system. And then to get to your question, Chairman Nethercott and Senator Kolb, we are moving to, or I think actually maybe it was Senator Kosk, we are moving to paperless courts. It will take a little bit of time in the federal courts. It actually took about 16 to 18 years. our courts we think will move much faster, but we have entered into a contract for electronic filing, and we are configuring the system right now for the Chancery Court and the district courts. And we hope to go to pilot in less than a year on those. And I think and one other thing about as to whether or not the rules are permanent. Yes, that the rules that were adopted, amending the requirements that require a district court clerks and circuit court clerks to receive papers by email and then file them into the computer system. That is a permanent rule. And the one last thing is that I'm trying to think. Maybe I've got all your questions. That was a permanent rule, and it would take another rule to ever change that. And we do not anticipate that happening at all, because again, we hope to be to electronic filing within 12 months. Now, it will not, Senator or Chairman Nethercott is absolutely right. It will take time to roll electronic filing out to every single district court. And that's all I have right now.
Questions for Ms. Sharp from the committee? Ms. Sharp, can you, is the $1 per page fee, is that a permanent rule?
Yes, it is a permanent rule. And again, in 5-2-202, what it provides is that other fees or charges to be assessed within the clerk's offices are to be determined under rules of the Supreme Court. Oh, and that was the other thing I was going to say. So when rules are adopted for the court systems, it is the Supreme Court who adopts those rules. So even if they're for the district courts, the Supreme Court is actually the body that adopts the rules.
And Ms. Sharp, can you maybe explain that a little bit further, how our court system operates in Wyoming? Are the district court clerks are elected officials? Does the Supreme Court actually have any supervisory authority over district court clerks or even district court judges?
No, we don't have supervisory authority over the district court judges. They are independent by statute, and the Constitution provides, well, the Constitution provides that they have the Supreme Court does have superintending authority, but the district courts also have inherent authority because they are constitutional courts. The district court clerks are elected county officials, so we don't have authority over them. But I can say that we all work together very, very well, and we cooperate, and all the clerks of the court worked with the Supreme Court and agreed upon the language for the rule changes. And especially, I would say during this COVID period, we have never had better cooperation than now. And I think that Patra can verify this, but I would say that we're all very excited for the new, so we are rolling out a new case management system in the district courts this year. And then we will roll out shortly thereafter, as soon as the district court clerks are comfortable with that system, we will roll out the electronic filing system. So I think we're all work together, and we're all very excited for the future. And hopefully, Chairman Nethercott, it won't be many years down the road. We hope that you'll see it in Laramie County within a year.
Thank you, Ms. Sharp. I appreciate that optimism. Questions for Ms. Sharp from the committee? Senator Kolb.
Thank you, Madam Chair. Good morning, Ms. Sharp. I'm confused. I don't quite get how this actually is working with this fee setting. I was under the assumption that the legislative branch set fees and the judicial branch didn't. I don't know what kind of authority is there to set fees such as the ones for the $1 a copy. I don't understand it. Could you please help me with that?
Sure. And I'm sorry, Chairman Nethercott. So it is by statute, and so that's actually, it's in 5-2-202 that provides for the collection of fees. And I would have to go in and I would have to look at the Constitution to see what, but whether or not and actually there are there are cases on it, not cases that I know of in Wyoming, but there are cases that provide for that the Supreme Court has inherent, in other states has provided that the Supreme Court has inherent authority to assess fees. But again, even if they're assessed, it is up to the legislature to appropriate them. So I can tell you historically, while I've been here, we have relied on the legislature always to set the filing fees. And that's part of the reason is there would be no reason for us to set fees that we couldn't use ourselves, or that you have to appropriate them. So it doesn't make any sense. So we have always relied on the legislature to set those fees. And so I can explain also. So if you'll see there is a general order that the Supreme Court puts out every year that sets forth what the fees are, and those are always consistent with statute.
Senator Cole, follow up.
Yeah, I understand you're dealing with an emergency and you're doing the best you can with the situation. I just kind of the belief that the legislative branch sets fees, and it's kind of their segregation of powers. But I do understand the situation, and I thank you personally for what you do, and thank you for your comments. Thank you, Madam Chair.
Any further questions for Ms. Sharp? All right, seeing none, thank you, Ms. Sharp. Is there anyone else in the public who'd like to comment on this bill? If so, please raise your hand. All right, seeing none, public comment is closed. I am going to keep Clerk Lindenthal and Ms. Sharp here, which I typically would not do. Give it back just 100% to the committee, but I'm aware that there is an amendment going to be proposed by, I think, a couple senators on the committee. And so as we work those amendments, sometimes it's helpful to have the stakeholders on the ground available to comment on those amendments, just so we have that feedback. So helpful to have them here just in case we need to do that. So hang with us a little bit longer, Clerk Lindenthal and Ms. Sharp. We appreciate you being here. So committee, the bill is back to you. Is there a motion on the bill? Moved by Senator Cost. Is there a second? Seconded by Senator Kolb. Any amendments, committee? Senator Cost.
Thank you. I do have an amendment suggested. It's on page 3, and it would be on lines 3 through, actually it's lines 3 through 8. I'm suggesting that all format requirements contained in any applicable rules shall be followed. The court may reject any paper filed that is not in compliance with this subsection. I'm concerned about creating formats that maybe are not available to others. And so I would ask that we consider deleting, starting with all on line 5 and going through subsection on line 8 and replacing it with documents in standard PDF form will be accepted. The reason for PDF form is that you can lock it down so that it can't be changed or anything. And it seems to be a standard that's easily read in all different formats. That would be my suggested amendment at this time.
Committee, there's a motion. Is there a second? And if so, then we would move to discussion. So seconded by Senator Kolb. Discussion on the amendment. Senator French?
Yeah, I would just ask, Madam Chair, ask Patra how she feels about that.
District Court Clerk Lindenthal, how do you feel about that?
No, I think that's perfectly acceptable. If this is going to go forward, then I think that's perfectly acceptable to add that amendment.
Ms. Sharp, give you an opportunity to comment as well.
Chairman Nethercott, I just wanted to clarify, would the purpose of this this amendment be to permit the clerks of court to accept other types? I just want to see what the intent is so that we, so I guess is this mandatory or permissive?
Senator Cost?
The basic idea with saying PDF form is that they can convert pretty much any of their forms to the PDF form by just saving it that way. I'm not going to say that it's a mandatory, but I'm just trying to make sure that we don't put a rule in that creates a problem for other courts, would be my concern.
Ms. Sharp, you satisfied?
Yes, that's fine.
All right, further discussion on the amendment? Although all those in favor, please raise your hand. Okay, that amendment has passed. Further amendments on the bill? Senator Kolb.
Thank you, Madam Chair. I would move to amend the bill by page 2, starting there, line 23, striking as it reads, any applicable fee set by statute or rule, the comma, striking that, replacing that with the clerk may charge 15 cents per page of email, and then add and. I'm sorry I didn't submit this in writing. I thought in the committee we could just we didn't have to do that. I'll change it in the future. So my apologies for being new.
No, Senator Kolb, you did it just perfectly fine. We accept amendments both ways. Commonly, they are just, they're not submitted in writing because we're working the bill in real time. And so perfectly acceptable, perfectly normal. Does everyone understand the motion, and is there a second? Senator Cost, a second? All right, discussion on the motion?
Question?
Question being called. All those in favor, please raise your hand. All right, that motion passes 4-1. All right, further amendments on the bill? Seeing none, roll call on the bill.
Madam Chairman, this is a roll call on Senate File 22. Senator Cooper.
Aye.
Senator French.
No.
Senator Kolb.
Aye.
Senator Cost.
Aye.
Chairman Nethercott.
Aye.
That motion passes.
All right, thank you, committee. It is 10 o'clock. We have been doing great work for the last hour and a half. I want to thank you for that. I think it's a good time to take a quick mid-morning break. So we'll break for about 7 minutes. I know it's an odd time, but 5 minutes is always too short and 10 minutes is too long on a short meeting. So we'll do a compromise of 7. So we'll see you back here at 10:06, 10:07-ish, okay? Be sure to mute your microphones and stop your video. Do not leave the meeting, just stop your video.
Thank you.
Well, welcome back, committee. If you are there, please turn your camera back on and we'll go ahead and get started. Looking good, senators. I like it. All right, we're back with the full 5 Senate. It's wonderful to see everyone together. The meeting is back and we're live and we are recording on YouTube. I want to send a message out to those that might be watching. Spoke with the committee this morning. We will be addressing Senate File 19, which is Public Health Emergencies Immunities, later this morning. I just want to make sure that those members of the public that might be interested in testifying on that are alerted to that issue. We're going to work the following bills in the following order for the remainder of the morning. We're going to do Senate File 23. Senator Kost, you'll explain that bill. We'll do Senate File 6, Senate File 19, and Senate File 20. Ideally, I would move Senate File 19 before Senate File 6, but as a result of time concerning Senate File 19, I want to allow for all of those potential stakeholders an ability to kind of jump up to speed and be able to attend. But that is the announcement for the way the bills will be reviewed this morning. So again, Senate File 23, Senator Kost, be on the ready. Senate File 6, Senate File 19, Senate File 20. All right, with that, committee, we're going to go ahead and start with Senate File 23. Senator Kost, are you prepared to explain this bill?
Madam Chair, I'll do my best.
Thank you, sir.
Senate File 23, this is to amend the current executive sessions to add one executive session, and that is down on page 2 is where you would see it. It's a part of statute 16-4-405, executive sessions. There's a list of executive sessions that are permissible. Currently, the only security is for national security, and amendment 12, or not amendment 12, I'm sorry, but section 12, or XII, is to consider, discuss, and conduct safety and security planning that, if disclosed, would pose a threat to the safety of the life or property, or of life or property, not of the. This bill was in last year and failed in the House committee. The amendment at that time was from the paper lobbyists, and they felt that this wording was better than the wording we had, so we've gone with that wording. We have received, and I don't know whether you have or not, but we have received emails that they are very comfortable with it this way, and the whole purpose of it was to give some flexibility to the need for security planning that was very, I guess, threatening to the safety and life of property and people. So you will see that. That is on page 2 on lines 1 through 3. There's the addition of that. And then down on line 11, because they added the 12th to it, that was crossed out the 11 XI and added XII. And with that, I would stand for any questions, ma'am.
Thank you, Senator Kost. Any questions for Senator Kost? All right, thank you, Senator Kost. At this time, we will move to public comment. Looks like we have, wonderful, those wishing to provide testimony on this bill. It looks like you're already doing so, but please continue to raise your hands and we'll take that testimony in the order in which it's received by those raising their hands. So first we have Mr. Brubaker. Welcome, Mr. Brubaker. If you would introduce yourself to the committee, and we look forward to hearing from you.
Thank you, Madam Chair. Appreciate the opportunity. Committee members, I represent the Southwest Wyoming Regional Airport. My name is Devin Brubaker. I'm the airport director here. I also represent the Wyoming Airports Coalition, and we stand in favor and ask for your favorable consideration of this legislation. As many of you are well aware, airports have access to and are responsible for many pieces of sensitive security information in terms of air travel. This legislation allows us to further discuss that information with our board of directors to make appropriate planning level changes as necessary to protect the traveling public as they work through our airports. So we just ask for your support and look forward to any questions you may have for the airports.
Questions for Mr. Brubaker? I always appreciate hearing public comment because when you first read a bill, you don't quite know all of the swath of people it might affect. And my first reading of the bill, I didn't think about airports, but certainly public entities that have a great need for security planning. So appreciate hearing from you. Provides a different perspective.
Thank you, Madam Chair.
Brubaker. All right, next we have, I think, Ms. Kaiser. Ms. Kaiser, welcome. Please start your video.
Thank you, Madam Chairman. I was actually just standing in line to provide support to Mr. Brubaker, and he's already made the statements. So thank you very much.
Always good to have backup, Ms. Kaiser. Why don't you introduce yourself to the committee, as I'm sure they'll see you again in the future.
Okay, excuse me. My name is Sherilyn Kaiser, and I am representing the Wyoming Airports Coalition. And so I would imagine that we will be speaking later today.
Thank you, Ms. Kaiser. Appreciate hearing from you. Looks like next up on the deck, we have Mr. DeCaria. Welcome.
Thank you, Madam Chairman, members of the Judiciary Committee. I'm Ken DeCaria. I'm the Director of Government Relations for the Wyoming School Boards Association. Madam Chairman, I know that Brian Farmer has testified on this issue during the interim, and he sends his apologies. He had some trainings that had to be done today. But the School Boards Association is in support of this legislation. Madam Chairman, as you know, that school boards have been entrusted with school safety and security and issues, and this bill will just make sure that the methods and the plans that they put together in order to keep students safe in the state of Wyoming is not just out there, so everyone knows what those plans are. And with that, I'm happy to answer any questions. Thank you, Madam Chairman.
Thank you, Mr. DeCaria. Any questions for Mr. DeCaria? I think a former senator as well. Is that correct?
That is correct. Thanks. That is correct, Madam Chairman.
What years did you serve?
I served from, let's see, 28 through 2009. No, it was before that. It was, I'm trying to think. I guess it was in the previous, so it would have been 2000. No, I served for 12 years, Madam Chairman. I'm sorry. I ended in 2009. I don't know why I can't think of that right at the moment. You know, you ask me those hard questions and they just flies out.
Clearly, you've blocked it from memory. A note for all of us. Wonderful to see you, and thanks for your service. Appreciate seeing you.
Thank you, Madam Chairman, members of the committee.
All right, next we have Mr. Mclaren. Welcome, Mr. Mclaren.
Good morning, Madam Chairman. My name is Bob Mclaren. I'm with the Wyoming Association of Municipalities, and we too stand in support of the bill. Don't need to say any more than that, but thank you for your consideration and urge an affirmative vote.
Thank you, Mr. Mclaren. Any questions for the Wyoming Association of Municipalities? All right, seeing none, appreciate you being here. Next, we have Jeremiah Riemann. Mr. Riemann, welcome.
Good morning, Madam Chairwoman, members of the committee. But first, if it's okay, I'd like to congratulate the new members of the committee, in particular Senators French and Senators Kolb, former county commissioner colleagues. And I am here to represent the County Commissioners Association. And we too support this legislation. There are certainly those times when it is appropriate for security measures to be discussed amongst commissioners, perhaps with the sheriff's office, in protection of the public. Commissioner French, I was thinking of the Hells Angels rally many years ago as perhaps one of those instances where that might have come up. You certainly were much more close to that, but that was one particular instance that popped in my head. So with that, Madam Chairwoman, we do stand in support, and I'd stand for any questions.
Thank you, Mr. Riemann. Any questions for Mr. Riemann? Senator Kolb.
Thank you, Madam Chair. Morning, Jeremiah. This has come up before at the county commission level, and it's been a kind of a black hole of authority that people have taken liberties in dealing with, because there wasn't a statutory change that specifically allowed this. So I think it's the absolutely a positive thing to do to codify the ability of all the government bodies that spoke here to be able to have an executive session discussing security. So it's a common issue, and I'm glad we're addressing it. More of a rhetorical comment, but thank you, Madam Chair. Jeremiah.
Thank you, Senator Kolb. Senator French, any comments on your participation with the Hells Angels rally? Undercover? Any efforts?
Yeah, I was undercover. I was one of the biker dudes all tattooed up. No. Yeah, we had a lot of meetings in Park County on that one, in the law enforcement center and that kind of thing. Yeah, the former county commissioner, we never, and I think most county commissioners across the counties, we never really liked to go into executive session. It was kind of one of those necessary evils, whatever the word is. So we never took it lightly. So that, anything that can give the any board or anybody the ability to, expand that a little bit, just for the public. The boards, and I know the commissioner, don't go into those lightly. We're not going in there often to discuss all kinds of things. We have a specific purpose, a specific threat, maybe, whatever it is. But I just want to assure everybody, we don't go into those lightly.
You didn't when you were a commissioner, and now you're a senator. So good to know. Those Park County commissioners are cautious, probably prudent. Mr. Riemann, any follow-up?
Yep, Madam Chairwoman, to both of their comments, they're absolutely right. Commissioners take this very seriously when they go into executive session. In fact, I generally receive a phone call when they're considering heading into executive session, just to confirm, hey, is there an exemption for this? Is this an appropriate time? Obviously they don't give me details, but they do reach out, and so it is a fairly infrequent thing that is used by commissioners.
Well, thank you, Mr. Riemann. Appreciate your testimony today. With that, I don't see anyone else here ready, or maybe Mr. Odekoven. Mr. Odekoven, welcome. I think we just let you in, so we'll give you a minute here to get your camera on. Welcome, Mr. Odekoven.
Thank you, Madam Chair. Byron Odekoven, representing the Wyoming Association of Sheriffs and Chiefs of Police, offering support for the bill and echoing many of the sentiments that were raised already, and mindful of the fact that, generally speaking, each of the entities that we've heard from, or that the bill contemplates, that security discussion would probably take place with law enforcement, whether at the city municipal side with the police chief, or at the county level with districts and groups with the sheriff. So law enforcement across the board is active, participates, recognizes the need for that executive level discussion, to have these kinds of topics reviewed so that we aren't letting the cat out of the bag, if you will, of what's planned or what is potentially there to be. So with that, Madam Chair.
Thank you, Mr. Odekoven. Great to see you. Committee, Mr. Odekoven, obviously representing the Chiefs and Sheriffs Association, appears in front of the committee regularly and often. So you'll get to recognize his face and very well. So good to see you again, Mr. Odekoven. Any questions for Mr. Odekoven? All right, seeing none. Thank you, Madam Chair. Thank you. I don't think there's any additional public comment on the bill. So committee, back to you. What is your pleasure?
I move the bill.
Moved by Senator Kolb. Is there a second?
Second.
Seconded by Senator French. Any amendments to the bill? All right, seeing none. Roll call on the bill.
Madam Chair, this is a roll call vote on Senate File 23. Senator Cooper.
Aye.
Senator French.
Aye.
Senator Kolb.
Aye.
Senator Cost.
Aye.
Chairman Nethercott.
Aye.
That motion passes.
All right, thank you, committee. We're doing great work. With that, we're going to move to Senate File 6, Public Works Contracting Requirements Amendments. We do have a number of participants on this bill. I think if those participants would start raising their hand now, I might bring you into the meeting sooner rather than later on this bill. Senator Cost, do you want to take a stab at walking the committee through this bill, and I'll help you out as well?
Thank you, Madam Chair. I'd be honored to do just that. As long as you're backing me up, I know I have nothing to worry about. So this bill is fairly lengthy, 12 pages in length, but the public works contracting requirements is relating to getting bids and going through the process of securing the proper or adequate materials for a bid on building something. This one starts out with Section 1, the duties of the department. And if you look at the department shell, what has been changed in on page 2, line 4 through 8 is adopt rules for the pre-qualification of bidders on contracts for public works as provided, excluding those public works under jurisdiction of the State Transportation Commission. Then down below there, you will see in procurement for capital construction projects, line 13 has changed, except as otherwise provided in Wyoming Statute 16.6.119. Each agency and the University of Wyoming are authorized to determine the qualifications. And that goes through talking about the bidders, the respondents for capital construction projects. And then on line 19, it says, except as otherwise provided in Wyoming Statute 16.6-119, each agency in the university may. So we get into the contract. You look at the very first thing on page 3, lines 1 through 3, the provisions of the statute that are applicable to this section and the conflict with the provisions of this section shall control over this section. In other words, those in 16.6-19 will take control over this section. If you notice on line 8, we have labeled that as A because we've added a B. And on 17 through 23, B is talking about each public entity shall specify reasonable performance standards for materials and equipment used in the construction of public work. The public entity may specify suggested individual brands or manufacturers, provided that similar materials or equipment that meet or exceed specifications shall be accepted as a substitute unless, and then we go through the unless down here. The contracted project is for an existing public work substitution of materials or equipment is unworkable, and the specified materials and equipment to be procured are not furniture or movable equipment not available from a Wyoming resident supplier as provided in Wyoming Statute 16.6-101A II and big A II. What we're really trying to do here is we're trying to say that you may have a project and we need to be able to look at all of the options for the bids for the materials for that project and all, as long as they're adequately meeting the standards of the necessary build. Sometimes people have a tendency to get into a favorite manufacturer or a favorite company, and that's not necessarily to the advantage of the bids in the state. And so it's necessary to look at all of that. On page 4, line 17, except as otherwise specified in this section, every public entity shall be authorized to determine the qualifications and responsibility of bidders. You look down on line 23, the end of it is inserted public, and then on page 5, entity that accepts a bid that is not the lowest bid for a public work shall provide a report in writing to the state construction department or to the state transportation commission, whichever is applicable to the public works. In other words, they need to know why you did. B, except for specialty project requirements as determined by rule of the State Transportation Commission or the State Construction Department, each public entity shall accept a bidder or respondent as pre-qualified for a contract for a public works if the bidder or respondent has been determined to be pre-qualified for the type of work pursuant to rules promulgated by the State Transportation Commission, pursuant to Wyoming Statute 24.2.108A, or the State Construction Department, pursuant to Wyoming Statute 9-2-3004 C and X, whichever is applicable to the public work. Then if on page 517, that works on down through the next part are the additional C, no public entity shall reject a bidder or respondent based solely on the financial strength of the bidder or respondent, so long as the bidder or respondent provides sufficient bid, payment, or performance bonds through the surety company approved by the public entity. We move on to page 6. You see D is the public entity shall accept a bid if it is determined that any of the unit bid prices are significantly unbalanced to the potential detriment of the public entity. Successful bidders shall ensure that any schedule of value that is required to be submitted for the project contains similar cost values for similar work. Moving on down, page 6, line 13 and 14. Basically, it says, enforce this act except no rule shall be promulgated under this section for the pre-qualification requirements in Wyoming Statute 16.6.119B. And then it goes on through the rest of the bill down on page 7, line 16 and 17 has an exception there, except otherwise provided in the statute, so that it covers the statute as changed. Down on page 8, you'll notice that it's been inserted again so that it's covered under the contracts for the county. And then if you go on down, page 9 has nothing on it changed. 10 has nothing, and 11 inserts on 9 through 11. Provisions of Wyoming Statute 16.6.19 that apply to this paragraph and that conflict with the provisions of this paragraph shall control. And that covers the bill. I would stand for any questions on it from there. And if you have any words of wisdom, feel free to provide them, Madam Chair.
Thank you, Senator Cost. Appreciate that help on a pretty big bill here. Committee, what I would do is if you have questions, you certainly can ask them now, but it might be prudent. I plan on inviting public comment in pretty soon. We have many of the stakeholders. I think we'll hear from Jeremiah Riemann again. Looks like we, and Ms. Legursky from the Wyoming Contractors Association, and they can help also provide some broad view explanation as to the bill. Mr. Mattson, Ms. Legursky, welcome. It's great to see you both. Committee, do you have any questions for Senator Cost or myself, or maybe the Contractors Association? We can all pitch in to help. Senator Cooper.
Could you give us just a little background on what brought this bill forward, these amendments, and why we need to make these changes, please?
Yeah, thank you, Senator Cooper. So substantially, the issue came before the committee from House Representative Clark Stith from Sweetwater County, who identified challenges in his community that he had experienced associated with this topic. And so he proposed some solutions that we have been working in the interim and hearing feedback about. So really a concern identified by a former member of the House Judiciary Committee, and that the Judiciary Committee also decided to take up as an interim topic at his recommendation and urging. All right, any further questions? Seeing none, and again, we can come back and answer those questions. Ms. Legursky, great to see you. If you would like to provide your comments and any further background information you think would be helpful for this committee to hear, really appreciate you being flexible and working with our quick and kind of crazy legislative schedule right now. So great to see you.
Well, thank you very much, Madam Chairman. With me today is Mark Mattson with WHS and Associates. He's here to answer any of the tough questions that I'm unable to. And of course, he's just laughing at me, but we do appreciate the time. During the course of visiting with a select committee of legislators during the interim, several of our members expressed concerns about the overly stringent pre-qualifications that public entities put on projects that preclude qualified contractors from bidding on a public works project. For example, we have a local courthouse that was put out to bid. The contractor that built that local courthouse was not allowed to put in a bid to do a remodel on it because they were not deemed qualified to do the remodel on the building that they built. For example, oftentimes public entities will put on stringent pre-qualifications to either go with a contractor that they're used to working with, or the design team sometimes likes to work with a contractor they've worked with in the past. For example, some of the stringent pre-qualification processes might be, in order to work on this particular courthouse, you had to build a courthouse a similar size in the last 3 years, or in order to build a school in the state of Wyoming, you had to build 3 schools in the last 5 years. When we started building schools, we hadn't built schools in the state of Wyoming for several years. That automatically took every single qualified contractor in the state of Wyoming out from bidding on a public works projects. The other concern that industry had was that by using the financial strength of a contractor to be pre-qualified from a project is overly stringent first. We oftentimes see on pre-qualifications that the financial strength that the contractor, they have to have a bonding limit of $100 million or $150 million, even though the project is only $10 million. So we believe if a contractor can bond the project, they should be allowed to be able to bid. The more contractors that are pre-qualified or more bids that are submitted for a public works is definitely in the best interest of the state of Wyoming and the public entity. More competition is good for projects. Competition keeps the price down. So during the course of the summer, we did express these concerns. The committee did listen to our concerns and took several recommendations from us to address the pre-qualification process. Since that time, the county commissioners did reach out to us. We have agreed to sit down and work directly with the county commissioners on setting up some sort of pre-qualification process that meets the needs of both the contractors and the counties, and moving forward to make sure that all qualified contractors can hopefully in the future bid on any county work project. So we definitely do appreciate them and their willingness to sit down and work with us. We do have one recommendation that if the bill is moved forward that we would like to see changed, and that would be on page 3, line 17, removing the word reasonable. so that it would read, each public entity shall specify performance standards. The word reasonable is really based on judgment. And what is reasonable to one entity or one contractor may not necessarily be reasonable to the others, but just by specifying the performance standards, that does the exact same thing. So we would encourage the word reasonable to be moved. That would be our only suggestion for the bill. And with that, we do stand in support of this bill, and I would be happy to turn it over to Mr. Mattson in case he had any further comments.
Mr. Mattson, welcome. We do want to hear from you, so please share with us your thoughts on the bill. We would be enlightened to hear your wonderful thoughts this morning.
Madam Chairman, members of the committee, thank you. Like she mentioned, Mark with WHS. I really don't have anything to add. I think Katie really covered all the parts to it. You know, the whole intent here is to clarify the process and keep it so that it's the most economically efficient for you all. There was some concern about that this somehow would apply to the standards. And so you can imagine, in my world, mostly horizontal construction, highways, streets, roads, that somehow that would apply DOT standards in places where they don't belong. I don't want to get in the weeds of it, but that's certainly not the intent. It was just their process on pre-qualification. And so if there's any questions in that technical nature, I'd sure be happy to respond to those. But thank you.
Thank you, Mr. Mattson. Any questions for Mr. Mattson or Ms. Legursky? All right, seeing none, stay close. We might call you back. With that, we'll move next to Mr. Brubaker. Good to see you again, Mr. Brubaker. Again, for purposes of decorum, please reintroduce yourself to the committee for those members of the public who may just be tuning in now to know who you are, and let us know your comments.
Thank you, Madam Chair, committee members. Once again, my name is Devin Brubaker. I serve as the airport director for the Southwest Wyoming Regional Airport. And I stand before you today representing the Wyoming Airports Coalition. We recognize the importance of legislation like this, and we understand the Contractors Association's concerns that have brought this forward, but we do have some concerns that apply to airports. This legislation requires that the State Construction Department or the Transportation Commission create pre-qualification requirements. Unfortunately, neither of those entities have any airport construction experience to create pre-qualification requirements. Oftentimes, airport projects have highly specific requirements that require experienced contractors that have airport experience to serve as the contractor on them. Second of all, the airports are governed heavily by Federal Aviation Administration and WYDOT aeronautics procurement policies. This legislation creates additional bureaucracy that we are concerned could slow our projects down and also increase the cost of our projects. One of the items that stands out to us right away is Code of Federal Regulations require that pre-qualification can happen during the bidding of a project. And in my experience dealing with the State Construction Department and the Transportation Commission, their pre-qualification processes do not allow for that pre-qualification to occur during bidding. And I could be wrong in that, but that's my experience. Additionally, airport public works projects are required to follow those FAA and WYDOT requirements. One of the requirements of this legislation would mandate that we would report to the State Construction or the Transportation Commission when we award to other than the low bid on projects. We already have to do that to the FAA, and we already have to do that to WYDOT Aeronautics. Adding additional reporting requirements to entities that have no oversight over airport capital construction creates concerns for us as well. So what it boils down to in short is that we would ask the committee to entertain the idea of excluding airport public works projects from the pre-qualification reporting requirements because of our concerns creating unnecessary redundancy and bureaucracy, and also putting our compliance with federal procurement requirements at risk. I'd be happy to stand for any questions.
Thank you, Mr. Brubaker. Helpful testimony. Do you have a proposed amendment for the committee to consider?
I would be happy to send one over to you all. I know that's too late for today. Hopefully we could consider it in first reading or second reading on the floor if this passes. But we're working on it. This really came on our radar late yesterday in discussions with DOT Aeronautics, and we're just trying to find a solution that once again could help airports maintain our compliance. So Madam Chair, be happy to supply one for second reading if this makes it that far on the Senate side.
Well, Mr. Brubaker, I think we're going to handle it right here this morning. So why don't you think
All right,
about it,
well,
and we'll come back to you. Senator
okay,
Cost.
sounds great. I'll get one together, Madam Chair.
Senator Cost?
Thank you, Madam Chair. Mr. Brubaker, the only thing I was making as a suggestion, rather than excluding the aeronautics, would it be better to add them to the prerequisites, saying that the three of them are all making the prerequisites so that they have a voice in it? So it would be the WYDOT Aeronautics Commission as well. And that would be my question.
Mr. Brubaker?
Madam Chair, Senator Cost, I want to be careful not to speak for WYDOT Aeronautics and their staff, but I would say that some language that would make sure that airport considerations are taken into account, whether that is by adding Aeronautics Commission or by requiring state construction or transportation commission to consult with the Aeronautics Commission to ensure that airport requirements are taken into consideration. I think that would be a fair amendment that would solve our concerns.
Follow up, Senator Cost.
Thank you, Madam Chair. The other question, the reason I was saying rather than excluding is because some of the offsite, maybe a cafeteria or something like that that's going to be added on, might not necessarily fall under the Aeronautics Division's building requirements. And I don't know, I'm guessing at this, but at the same time, if they're excluded, they could kind of do whatever they want. And I'm just thinking, would that prerequisite maybe help to hold those accountable to the same thing we're trying to issue at this time?
Mr. Brubaker?
Madam Chair, Senator Cost, I do not disagree whatsoever, and I'll throw together a quick amendment here that would add language that would protect airport interests, but still require the pre-qualification basis.
Senator Coe?
Thank you, Madam Chair. Morning, Mr. Brubaker. Long time no see, sir. Yeah, I think if we had excluded anything that it was connected to federal dollars that had to have some sort of authorization by the FAA or WYDOT and include everything else, you know, besides those issues that would be federally mandated or, you know, that you'd run into conflicts with. I think that so they're trying to solve another problem. And of course, you have to consider all issues. So that would be my comment about it, if it helps. Thank you.
Thank you, Mr. Brubaker and Senator Coe. Mr. Brubaker, stay close.
All right.
We'll look forward to your thoughts. Come to this committee with solutions, not just problems. All right, with Mr. Riemann, looks like you're on deck.
Good morning again, Madam Chairwoman, members of the committee. Again, I'm Jeremiah Riemann with the County Commissioners Association. Wanted to start off by saying that we agree with the intent of what is trying to be accomplished here. There is the potential to help counties in a uniform fashion, as well as to help our contractors across the state. As I've expressed through the interim, and I'll do today, there is a concern about loss of local control for local specific projects that are under jurisdiction and that may be unique. You just heard one example in terms of airports, which certainly in most instances have a county connection. We could also be talking about water and sewer projects for which the state generally has no responsibility for, but local governments do across the state. We have been interested in trying to find a solution. As Ms. Legursky mentioned, we've been working with them and talking about the potential of moving towards a model that could be, again, beneficial to them and beneficial to us. I'll just give one example of a model that exists in current state statute where the two of our organizations, along with other members, do participate. Where actually it's one of the unique places in state statute where our two associations are written into statutory language. And that is relative to the County Road Standards Committee. And they have oversight and jurisdiction and responsibility for evaluating how counties spend county road maintenance funds across the state. That committee is established in 24-2-110F. And again, it includes a member of the Council of Engineering Companies of Wyoming. It includes members from the County Commissioners Association, and it includes Associated General Contractors, as well as other representatives appointed by the governor. That's one model, perhaps, for how we could deal with the county specific projects and allow us to collectively work as associations to develop pre-qualification standards. So I would bring that for your consideration. I would ask that either counties be removed from this legislation, and that, if my analysis is correct, is pretty simple. And that would be to go to page 8, lines 9 and 10, sorry, and remove the except as otherwise provided language, which then ties back to the pre-qualification standards. If the board, based on the conversation today, is interested in seeing counties develop pre-qualification standards, you could take out that language and perhaps insert something like is included on, let me get back to it, put in language that would require counties in that same section to adopt rules for pre-qualification of bidders on contracts of public works projects, and force us to develop those. You could perhaps do that as a statewide approach, which I think is generally what the contractors would prefer. But that language that I just suggested follows what is included for the Department of Transportation on page 2. So without some sort of amendment, we will oppose this bill, but we would like to get to a place where we can support what overall is a good intent. And with that, I'd be happy to take any questions.
Thank you, Mr. Riemann. Questions for Mr. Riemann? All right, seeing none, Mr. Riemann, stay close as well, please. I think we'll be calling on you again later as we hear further public comment.
Great, thank you.
All right. Mr. Mclaren, good to see you again.
Madam Chairman, thank you. Nice to be seen again. Bob Mclaren with the Wyoming Association of Municipalities. I guess our comments sort of are similar to what Mr. Riemann said. We're a little bit concerned about the lack of control of being dictated to by the transportation department or the state building department. Would be willing to work, and we've had conversations with the contractors, with Katie and Jeremiah, about how we could work collaboratively together. We don't think the bill is necessary at this point, but happy to try to work with you to develop some pre-qualification standards. If we can't do it with the contractors in the counties, then the WAM could do it for just the cities. But it would seem to me that if we're going to go down this road, that we would do it with the counties and the contractors. So there's sort of one set of standards and not one for cities and one for counties and one for airports and one for SIDs. So right now I'd say we're opposed to the bill, but we're happy to try to work to accomplish the intent of this legislation.
Mr. Mclaren, if you would, can you explain what you think the purpose of the legislation is?
My understanding of the purpose of the legislation is to make sure that all contractors are called, to develop a list of contractors to basically have a broader base when you're trying to bid a bill. And I understand from Ms. Legursky in some cases that contractors have been excluded, and so we're trying to level the playing field, if you will, is my understanding of the intent of this bill. And I understand it came out of Rock Springs. I'm a little bit familiar with that situation, and I'll tell you, there's two sides to every story, but we are where we are, and we want to work with the legislature and the contractors to get the best value for the citizens of Wyoming when we build projects.
All right, thank you, Mr. Mclaren. I appreciate it. All right, next up, any questions from the committee? All right, Senator Cost.
Thank you, Madam Chair. Mr. Mclaren, so rather than saying possibly on page 2, line 14, where it says each agency and the University of Wyoming, if we would maybe try to list the agencies that would maybe best need to have input into those pre-qualifications and all, would that be a more appropriate or a more favorable move for you?
I believe so, Senator.
All right, thank you, Mr. McLaurin. I appreciate it. All right, just for everyone to be aware, I anticipate that if the bill gets moved, amendments are going to be made. And so I would ask everyone to stay close in the event we want to call you back as a result of some of the factual complexities with this bill. We always like to hear from the stakeholders what an amendment may or may not do from your perspective. So again, stay close. With that, it looks like we have Mr. Gillett next on deck. Mr. Gillett, if you're there, if you would start your video. Welcome, and please introduce yourself to the committee.
Yes, thank you, Madam Chairman. I'm Mark Gillette, Chief Engineer for WYDOT, and I would reserve my comments and so forth after Director Reiner makes his comments.
Absolutely, Mr. Gillette. Sorry, I butchered your name there. I have it correct now and have taken note, so appreciate you being here. We will move, next is Director Reiner here. Can move him in. I don't see that he's in the waiting room, so maybe he'll join us later. If not, we'll keep Mr. Gillette close as well. Oh, there's Director Reiner. Welcome, Director Reiner. Good to see you again.
Thank
Committee,
you.
Are you seeing a theme, committee? The same faces?
Thank you, Senator, members of the committee. For the record, my name is Luke Reiner, Director of WYDOT. I appreciate our Chief Engineer, Mark Gillette, being on. Hey, really from a WYDOT perspective, certainly we've been involved in the development of this over the interim. To the question about the state Aeronautics Commission, I don't think from our perspective we have any issue at all adding that to my understanding would be page 5 to that list, and that would be appropriate if you choose to include airports and just have them report to the State Aeronautics Commission. We certainly have worked with both of those commissions. So and then really the other comments, we will continue to monitor what's going on with the bill. I think our only question at this point relative to the bill would be certainly Section 2 requires us to adopt the rules necessary to implement this act. And the rule that I think we would be discussing here is the ability for us to receive reports from what I would be tracking now as horizontal construction public entity projects, and now the potential to receive reports from airports through the State Aeronautics Commission would be the two rules that we would need to make. I probably would appreciate a little bit of further intent in terms of what the reports are for, and what the disposition of the reports is, and what the follow-up on the reports are, just in terms of roles and responsibilities of our agency. Other than that, the way we read the bill is that really this bill adopts the procedures that we use on a daily, monthly basis as we go about our business of bidding roads throughout the state. Madam Chair, that's really a brief comments from me, and with your permission, would maybe pass it to Mr. Gillette, and then we stand for whiteout questions from you as a whole.
Sounds great, Director Reiner. Thank you. Mr. Gillette, come on back. Great to see you again, Mr. Gillette. Any follow-up from the director's comments?
Madam Chairman, no, I don't really have any further comments other than, again, the intent of the reports that we might receive. In other words, what do we do with those reports? Thank you.
A great question for all of our state agencies. Thank you, Mr. Gillette. Questions from the committee? All right, thank you, White. I'd appreciate hearing from you. Okay, if there's any other public comment at this time, if you would please raise your hand. All right, seeing none. Oh, looks like maybe there's one. Mr. Brubaker, are you coming back around? We'd love to see you.
Madam Chair, if this is the appropriate time for the proposed amendment, I have one crafted for you all.
Wonderful. Why don't you share it with us?
All right. Madam Chair, I want to also say I cannot pretend to be nearly as good as your LSO staff here, so please bear with me in my wording of this, and they, I'm sure, will correct my errors. What I have is on page 2, after line 8, inserting an additional paragraph that says, in the promulgation of rules for this section, the department shall ensure that specific pre-qualification requirements are developed for airport-related public works projects. Such promulgation of rules shall be coordinated with the Aeronautics Commission. The rules shall grant an exemption for airport public works projects funded with federal funds that require compliance with federal procurement laws.
Mr. Brubaker, that sounds well written. Do you think that you could email that to the committee?
I absolutely can, Madam Chair.
Wonderful. All right, Mr. Brubaker, just stand close by. I appreciate your quick efforts. I knew you could do it. All right, committee, there's no further public comment, so the bill is back to this committee. Right now, I would entertain a motion on the bill if you're so inclined.
I would move the bill.
Moved by Senator Cost. Is there a second? Seconded by Senator Kolb. All right, committee on the bill. Now is where we'd work the bill with amendments. You've heard a number of concerns. Again, all of those stakeholders are close by. If you want to reach out and talk to them, I'm happy to entertain that, even though it's somewhat untraditional. Senator Cost?
I have the First Amendment to add, if so desired, ma'am.
Proceed.
On page 3, line 17, the suggestion was to remove reasonable because it's difficult to determine what reasonable actually means. Specify performance standards, so it would read, each public entity shall specify performance standards for the materials rather than reasonable. I would say it's difficult sometimes to interpret what reasonable is, and reasonable to me and reasonable to you might be different. So I would make the, I would move the amendment to remove reasonable from that line.
Is there a second? Seconded by Senator Cooper. All right, any discussion on the amendment? All those in favor, please raise your hand. That motion has passed. So the word reasonable has been struck from page 3, line 17. Further amendments on the bill? Senator Cost.
Thank you, Madam Chair. I would also entertain making the motion after line 8 that was so eloquently spoken by Mr. Brubaker, and I was starting to copy it down, but I wasn't as fast as his reading was, so I don't have it yet. But I would also amend it to read that.
Is there a second on Senator Cost's motion to adopt the proposed amendment by Mr. Brubaker?
And that's after line
Page
line
2,
8.
line 8.
Right.
Looks like that was seconded by Senator Kolb. Discussion on that amendment. Senator Kolb.
I would like to receive the document from Mr. Brubaker to review it before I have any further comment, Madam Chair.
I don't see it yet, so we'll just stand by. We do know he can do things quickly, so. Senator Cost, do you have further comments?
I was going to say it just popped into my email, so it should be coming quickly. I had one comment, and that is this the only part we want to add, or do we want to consider Wham and the county commissioners in there or not? And I guess I would ask those two that have been county commissioners what their thoughts are in trying to do something there, because we'd have their insights on there.
Senators Kolb or French, any comments? Senator French.
Thanks, Chairman. Senator Cost, you know, as they stated, local control is really important to all of the counties and the municipalities. So, you know, I think I'm troubled by this bill and the airport thing. That's fine what was said there, but you know, I think we need the municipalities and the counties to give us more direction, more ideas. They need to be very involved, like they requested, essentially, on these. I know as a commissioner, and Senator Kolb will probably agree, you know, we do a lot of projects, and to be able to say for whatever county, pick your county, Park County, Sweetwater County, whatever it is, that, you know, the people in that county entrusted us as, say, a commissioner or a city council or whatever to do these projects. They need a real say in what those qualifications, all that is. I mean, I just question if we're ready to go further with this bill. So that's my 2 cents.
Thank you, Senator French. Senator Kolb.
Thank you, Madam Chair. Yeah, of course, we always want local control. You know, the story goes, it's always best decided locally. I think, though, I did talk to Representative Stith about this bill and kind of get a little bit of background on it. So I knew why it existed or why it was brought forth. And one of the main issues was the fact that the preloading of bid prices or preloading of requests for payments that in fact took away all the recourse that an entity may have in some contractor not fulfilling the contract. So there wasn't a recourse built in because they had been paid up front basically for the profit. And I know that was one of the reasons for it. I think that's a valid point, that sometimes, especially for our smaller municipalities, they don't have expertise on staff to maybe see these kind of things. although I just backtracking on what I talked about local control, I think there is a need to have a bill such as this. I think it's maybe has some faults in it because, you know, we're working on them. But I think it's necessary to talk about it. So I'm not ready to give up on this proposed legislation. I think we can work on it and do the best we can in committee, Madam Chair. So thank you.
Thank you, Senator Kolb. Senator Cost.
There we go. Thank you, Madam Chair. The other suggestion I would say is maybe if we're not real sure on the WAM and county commissioners, we could work that part once we get into committee of the whole as well. What are your thoughts? You think we can work on that here? I don't know. I have mixed emotions on it both ways because I want to make sure that we get the best bids, but I also want to make sure that we're doing what's right by allowing different construction or whatever people to be able to bid on those that could qualify.
Yeah, thank you, Senator Cost. There is an opportunity to continue to work the bill, certainly in the Senate. There are a number of readings with a number of amendments that can come through. I'm not certain when this bill will hit committee of the whole, whether it will be when we meet via Zoom for the 10 days or whether it will be in March when we're live at the Capitol. Probably as a result of the complexity of this bill and the need for the stakeholders to participate. If we move the bill forward, I probably would ask that it not hit committee of the whole until March. There's nothing urgent happening with it. And so that allows, I think, the County Commissioners Association and WAM and others to continue to have those conversations to see if it can be supported by everyone involved. And also allows us to have, I think, maybe more in-depth conversations on the ground in March. Also, if it does pass out of the Senate, theoretically, it would hit the House Judiciary Committee, and the House Judiciary Committee would then have the ability to work the bill there as well, just like we're working it today. And then it would go through the House's rendition of multiple readings and amendments. So there is ample opportunity to fix it if the committee wishes to continue to try to do so. So those options certainly are available. Senator Cooper.
I'd like to say thank you to Mr. Brubaker for the amendment and for him putting that together in such a expeditious fashion. He did a great job there. I would literally like to see WAM and the county commissioners more involved so that we maintain our home rule and our local input. So I'd call on them to give us the amendments that they need as we go forward with this bill to make sure that they are included before it actually is finalized. Thank you.
Thank you, Senator Cooper. Just so the committee is aware, the county commissioners and WAM have participated with the bill through the interim. I mean, so they have been a part of every meeting and we've heard feedback from them. So I hope to continue to do so. And I understand, Senator Cooper, your comment concerning having them included into the bill draft. So just for a point of clarity there. Mr. Brubaker, I see maybe you're back and I have not received your email, but I think Senator Cost did. I refreshed my email. Maybe some of the other members have. Mr. Brubaker, go ahead.
Madam Chair, I'll double check and make sure I typed your email correctly in my rush to get it to you quickly. I apologize if I misspelled something in that. In speaking while you all have been doing your discussions and speaking with the aeronautics administrator for the state of Wyoming, he was concerned that we may have placed that amendment in the wrong location. And maybe if it's all right with you to check with LSO if it would be better suited under Section 2, because it may be better for the Transportation Commission to work with the Aeronautics Commission versus the State Construction Department working with the Aeronautics Commission. And I think that's where some of our confusion is having two different entities that have two different responsibilities versus horizontal and vertical construction becomes a little bit more complicated when it comes to airports because we do both.
Wonderful, Mr. Brubaker. Thank you. Senators, do you have that amendment in your email? Please raise your hand if you do.
I forwarded it to you, Tara.
All right, thank you. Mr. Brubaker, all is forgiven if you misspelled my name. It's a doozy. So not to worry, I'll have it. It is received. Committee, I'll give you a chance to read it, make sure you feel comfortable with it, and then potentially evaluate the proper location of it. So I'll give you just a second here.
Madam Chair.
Yes, Senator Cost.
And where was the other place that Mr. Brubaker was thinking about having it?
Mr. Brubaker?
Section 2, Madam Chair, would be the other potential location. I think the wording of it might need to change slightly. In the current recommended location, it references department, which falls in line with the wording of page 2 there. But if it moves under section 2, it may need to be reworded slightly. Once again, my skill set compared to your LSO staff is marginal at best.
So we're on page 11 of section 2. Committee, as a reminder, and Mr. Brubaker as well, unlike the interim, we currently are not staffed with LSO attorneys. So we have got to figure this out kind of ourselves. We do have LSO staff who's kind of taking record of what we're doing, but they're not LSO attorneys who would be doing the drafting. And so really important difference there as opposed to the interim for how this work gets carried out now that we're in session. Senator Cost.
Thank you, Madam Chair. In reading section 2, that might be more appropriate because it says the State Transportation Commission and the State Construction Department shall adopt rules necessary to implement this act on or before July 1st of 2021. It may be necessary to say that we need to go through other parts and add them in. I'm not sure, but I definitely think this would be the place where first it probably should be considered.
So Senator Cost, is your motion to have that language inserted onto page 11 in section 2?
It is, Madam Chair, and to make sure it reflects both the state transportation and the state construction department, so that it's reflecting both of them, the commission and the department.
Senator Kolb, is that friendly? Kat, you're on mute.
I'll say yes.
Okay. Ms. Legursky, Mr. Madsen, I'm going to call you back. Senator Kolb.
Thank you, Madam Chair. Yeah, I was looking at the insertion on section 2, and I was thinking possibly accept airport public works projects funded with federal funds that require compliance with federal procurement laws, and then continue on, the state and exclude that the airports from section 2. I don't know if that would be acceptable or not. So it'd be a friendly amendment to Senator Cost, I suppose.
Senator Cost, do you find that friendly?
I guess my concern is not wanting to necessarily exclude them from everything, but to exclude them only from what they've listed here, the federal works funded with federal funds that require compliance with federal procurement. So I'm thinking maybe the insertion there would be almost exactly what they have here, except in the promulgation of rules for this section, the department and the commission shall ensure that specific pre-qualification requirements are developed for airport-related public works projects. Such promulgation of rules shall be coordinated with the Aeronautics Commission. The rules shall grant an exception for airport public works funded by the federal funds that require compliance with federal procurement laws. It would be my suggestion to just add to department and the commission. And that way it would cover both entities as they're going through those to work with the Aeronautics Commission. That would be my suggestion. I'm open to what
You muted yourself, Senator Cost.
did, and I apologize. I was rambling and thought I better shush. I was just kind of worried about certain building of projects or something that may be just fine without excluding them. And I would hate to have that create some kind of a problem.
So here's what I'm going to propose that we do. We are on discussing the amendment. I don't think it's clear for staff or the public the actual amendment at this time because we've had a couple of friendly amendments and changes. So in order for clarity and to dispose of this amendment, what I'm probably going to ask you to do is I'm going to call question on the amendment, encourage you to vote no on the amendment, have Senator Cost rethink about his amendment or Senator Kolb and repropose the amendment so it's very clear for everyone involved about what is actually being amended. In the meantime, to buy you some time and to formulate some of those thoughts concerning your amendment, I'd like to hear from the Contractors Association about just exactly what it is that we're doing if they have any comments or thoughts. So Ms. Legursky, welcome back. Mr. Mattson, any thoughts?
Thank you, Madam Chairman. Katie Legursky with the Contractors Association. We had a little hard time following some of that discussion as well, especially when it comes to federal funds. The one thing that we would add to it as well is maybe bring YDOT back on the line to see if they need to be included with the federal funds that come down through the Federal Highways Administration to make sure we're in compliance with those as well.
Thank you, Ms. Legursky. Come on back, Director Reiner. And Mr. Brubaker, perhaps you can answer that question. Ms. Legursky mentioned federal highway funds. I heard you mention FAA. We've got multiple flows of federal funding here, it sounds like. So you might want to think about providing any clarity to any of those concepts. Welcome back, Director Reiner. Have you been following along on the conversation?
Madam Chair, I would also like to ask if you'd bring Mr. Gillette back. This is his area of expertise.
Absolutely. Committee, while we may wait for him to come back, I'm going to call question on that amendment. All those in favor of Senator Cost's amendment to add the language from the aeronautics, addressing the aeronautics piece, please raise your hand. Seeing no hands raised, that amendment has failed. So there's no amendment addressing that issue on the table. So again, I'd encourage you, if you want to please reformulate your thoughts as to that amendment. Mr. Gillette, are you still there? There you are. Wonderful to see you again. Thanks for hanging in with us. Hopefully you've been able to follow the conversation. Ms. Legursky asked a question from the Contractors Association about concern over federal highway funds, I think, and I think Mr. Brubaker mentioned FAA funds, and so maybe some clarity as to the proposed amendment as to the flow of those federal funds. Mr. Gillette, can you hear us?
Madam Chair, yes, I can hear you. Would you please restate the question?
Absolutely reasonable for that to occur. So Mr. Brubaker identified a concern that some of the maybe pre-qualification requirements and reporting requirements may interfere with some of the federal funds that the airport operators receive. And I think those federal funds may come from the FAA. Is that correct, Mr. Brubaker? I'm seeing a nod of the head.
It is, Madam Chair.
Yeah, as we move this amendment forward, Ms. Legursky from the Contractors Association mentioned also that YDOT may want to provide some input as to that conversation and any other concerns that YDOT may have as funds flowing from the Federal Highway Administration. If you have any comments or concerns about that.
Madam Chair, certainly the federal funds that flow to YDOT, the rules that we have in place and the pre-qualification bidding and et cetera certainly cover all those federal funds.
Ms. Legursky, do you feel confident?
I do, Madam Chairman. Thank you.
All right, thank you so much. Senator Cost, Senator Kolb, thoughts about an amendment? Senator Cost.
I will make a new amendment and send it to everybody to insert after page 11, section 2, in the promulgation of rules for this section, the department, YDOT, and the commission shall ensure that specific pre-qualifications, requirements, you know what I just thought? I don't think YDOT should go right there. I think I screwed up. So I'm going to have to say on hold for a second, please.
Sure. And committee, what we might do is there's another option too, where we can table this bill to March, if you'd like to, as an option to consider. Senator French would like that very much. Senator French.
Madam Chair, I would like to table it.
All right. Moved by Senator French to table, and it's up to the committee. We can keep, this is what we're here to do, is to work these bills. So really it's at the committee's pleasure, but if you feel more comfortable to do that, I think that's fine. Again, there's no urgency onto this bill. We can get it worked out in March at another one of our committee meetings where we're live and in person. So it's up to the committee. Is there a second to Senator French's motion to table? Seconded by Senator Cooper. Any discussion on the motion to table until March? Seeing none, all those in favor of the motion to table till March, please raise your hands. That motion has passed. More pain and suffering, Mr. Brubaker, Ms. Legursky, thank you, and YDOT. Continue to work on it. And stakeholders involved with this bill, what is most helpful, as you saw Mr. Brubaker do, to come with the proposed amendment, and the same as the Contractors Association, if there's an error with the bill that you see that you want changed, very specifically identify how you'd like that word, that language to be changed to what you want. You're more likely to get what you want if you ask very specifically what it is. And so as you come forward, and that goes to the County Commissioners Association and the Wyoming Association of Municipalities, I expect to see language in March. If not, we'll bumble our way through it, and word of caution to the wise. So thank you so much, all those involved on Senate File 6. Appreciate all the hard work. Okay, with that, committee, we're going to go to another doozy. And as indicated with our plan this morning, we're going to do Senate File 19. We have an hour left to do this bill before we hit our 4-hour hard stop at 12:30. So just a comment to the committee and to, I think, the high volume of people who intend to testify on this bill. It's a big bill. I will walk through it essentially concerning this bill, and the committee, I think we've discussed it before informally. As Senator Cost recalls, and as information for the new senators and for members of the public, the issue with COVID-related liability and immunity was a very hot topic at the start of the pandemic in March through June, and everyone was very much aware and had these concerns associated with potential litigation associated with negligent or tort liability associated with the contraction of COVID. When the legislature held its special session in May, the legislature reviewed really 3 large bills associated with a number of emergency relief programming associated with the pandemic and CARES Act funding. As part of that bill, I believe it was Senate File 2, it was the second bill, the good President Perkins of the Senate at the time proposed particular legislation in that bill that allowed for workers' compensation to be a compensable injury under Wyoming workers' compensation law if an employee obtained COVID. And so workers' compensation will cover COVID in the event an employee contracts COVID. There is a presumption in favor of coverage, and there's a presumption essentially in favor that the employee or the worker did contract COVID while in employ. Now, some of you may think, oh my goodness, that's a pretty bold move, and it was. However, in Wyoming, workers' compensation is the sole and exclusive remedy, and I want to just underscore and bold those words, sole and exclusive remedy, to an employee who's been injured, and therefore they can't sue the employer for receiving that injury, and their only remedy is through the workers' compensation fund. And so that particular bill, excuse me, put forth by the good effort of President Perkins, really cut off any causes of action from employees to their employers for contracting COVID. And it didn't leave employees without a remedy. It provided the workers' compensation fund as a potential, as the only remedy available to those employees in the event they contracted COVID. So really important as we talk about COVID immunity and COVID liability, that for the employee-employer relationship, that full protections are currently in place concerning that really are very strong, the strongest that I think that we could provide. So then the second factor that came to be that caused the business community great concern as the state grappled with how to reopen the state was the concern over customers suing businesses or other like retail establishments or restaurant establishments or lodging facilities for contracting COVID. And so this particular bill tries to address those concerns because the business community didn't feel like the efforts done in the special session in May were sufficient enough. Despite that, two things happened, and one, that workers' compensation piece as I addressed, and secondly, there was an effort to provide this type of coverage in the special session. It really created it really locked up the ability to pass many of those bills and essentially held some things hostage. The Wyoming legislature back in the early 80s, I believe, already had legislation in place to provide immunity protections to healthcare workers associated with providing treatment during a declared pandemic or health emergency, and also provided immunity protections for volunteer healthcare workers. So for example, in the event a retired doctor needed to get called back into service but didn't have malpractice coverage or any other type of protections associated with them being, in a practicing situation after having retired, it afforded those professionals immunity protections as well. So pretty profound work of the legislature before us almost 40 years ago, to the best of my recollection. We enhanced that provision in May to include immunity protections for businesses with a standard that said if a business or a medical professional exercised good faith in responding to a pandemic, that they would have immunity. And that's what the law currently states. A business community still insisted that that wasn't enough. And so we have two bills currently pending in the Wyoming legislature, one in the travel committee that they heard yesterday and one in this committee. Both have been worked in the interim simultaneously by stakeholders and law firms and other entities within our state concerned about this issue. I think it's important to note that as a measure of calm and to encourage businesses to reopen, that I am not aware of any litigation within this state concerning the contraction of COVID by a business to a customer. And so there's that. But this bill is before the committee as a result of the Judiciary Committee being tasked with continuing to work this issue from concern from the business community and those stakeholders. And so this bill was presented to us through a working group really made up of members of the Business Alliance and the Wyoming Hospital Association and some legal professionals that presented the bill to us, and then our committee also made some amendments to as well. So if you look at the bill, you can see that it is immunity amendments. It addresses 35.4.114, which is immunity from liability. During a public health emergency as defined by the statute, any healthcare provider or other person, including a business, which is the language that was added in May, which is now being stricken, or entity who is in substantial compliance with orders, guidance, or instructions, or who in good faith follows the instructions of the state health officer or a Wyoming city, town, or county health officer, because in Wyoming it's not exactly clear who should be issuing safety health order. Should it be the state health officer? Some folks say no. Should it be your local county health officer? Some folks say no. Should it be a municipal health officer? Some cities don't have that. And so this says whoever your directing health officer may be providing instructions, if you are in substantial compliance or in good faith with those instructions, that any acts or omissions of those persons or entity which causes another to be exposed to or contact the disease, agent, or toxin for which the public health emergency is declared shall receive immunity. I'm not in love with this bill, but I believe that we should continue to work this bill. I believe that there was a fixation over the businesses and retailers, and as a result of that preoccupation with that piece, the original purpose and intent associated with this statutory section almost 40 years ago has been missed, and the protection associated with healthcare providers may have been jeopardized with this bill. But I look forward to hearing public comment and learning more about it. And so that's the bill. Senators, do you have any questions? Senator Cost.
I don't have a question. It would be more if we move the bill. But on page 2 where it says substantial, I'm struggling with that word because that becomes a judgment of somebody, and I'm wondering if we need to remove it from it. But that's more of when we discuss the bill than now, so I apologize for interrupting.
Thank you, Senator Cost. I think that's a fair question to be thinking about as we hear public testimony. Any further questions from the committee before we turn it over? All right, seeing none, again, as a member to our attendees and participants who intend on testifying, we have an hour. I know that there's a great level of interest in this, and I see a number of people ready to participate. So it may be necessary for me to limit the time associated with your testimony, but for now, there won't be any time limit. Please raise your hands with your interest in testifying, and I will go in the order of which I received those hands. And so first off, I think that we have Miss Sheila Bush, I think, is coming into the room as we speak. Welcome, Miss Bush. Great to see you. If you would introduce yourself to the committee, we'd love to hear your thoughts.
Good morning, members of the committee, Madam Chairman, Sheila Bush with the Wyoming Medical Society. I will be brief. I do believe the Department of Health and Public Health Officer Allie Harris may be available for comment also. I don't see her. I don't think I have that ability with my Zoom space, but if she is here, I would certainly defer my comments to our Public Health Officer if that's appropriate, Senator Nebekov.
Absolutely, Ms. Bush. Questions for Ms. Bush from the Wyoming Medical Society right now? We'll have her stay close by as we welcome Dr. Harris to the committee. Welcome, Dr. Harris. I think you're testifying in front of a number of committees you typically don't see, but great to see you now. We look forward to hearing your comments as well. So I think everyone knows you, but again, for purposes of decorum, introduce yourself and share with us your comments.
Thank you, Madam Chairman. My name is Allie Harris. I am the State Health Officer at the Wyoming Department of Health. I also have with me Dirk Dykstol, who's the Chief of the Health Readiness and Response Section. As you had mentioned, Madam Chairman, and as Ms. Bush mentioned, we do want to express some concerns about how this bill would limit the scope of the immunity from liability specifically for healthcare providers. The way that this bill would limit the scope for healthcare providers is by granting immunity only for causing somebody to be exposed to or to contract the disease. And so for healthcare providers, that immunity during public health emergencies would be important for many reasons, in addition to just causing somebody to be exposed to or contract the disease. We think the most important example of this is situations where scarce medical resources need to be allocated. During public health emergencies, there may be situations in which there are not enough resources, such as beds, ventilators, treatment medications, or even healthcare providers themselves to be able to provide life-saving care for all patients who need it. We are thankful that we have not had that level of crisis in Wyoming during this public health emergency. But if it were to happen, the Department of Health would release guidance on how healthcare providers can allocate those limited healthcare resources to preserve the most life. One specific example of this that didn't happen here, but did happen in other states during the pandemic was the initial availability of the treatment medication called remdesivir, which can be used to treat hospitalized COVID-19 patients. When remdesivir was first available to states, it was in very limited supply. And so some states had many more hospitalized patients than they had doses of this medication. So these states issued guidance for providers on how to allocate those medications, often prioritizing more severely ill patients over less severely ill patients who otherwise would still be eligible to receive the medication per the authorization. So you can imagine a scenario in which a provider did not treat an eligible patient with the medication because they were following the state's scarce resource allocation guidance, and there simply wasn't enough medication for all patients, and that provider could face liability for not giving that treatment. But in this bill, that provider would not be eligible for that immunity from liability because they didn't cause that patient to be exposed to or contract the disease. As you also mentioned, Madam Chairman, the original intent of this statute was to provide immunity for healthcare providers who follow public health guidance. And while the department does not have any concerns with expanding immunity from liability to businesses, we are concerned that this bill inadvertently reduces the scope of immunity for healthcare providers in doing that. So one suggestion that we had, which we did also talk about with House Bill 59 yesterday, is essentially to create two parallel tracks, one for healthcare providers, which would keep the language essentially the same in 35 or 114A for healthcare providers, and then potentially creating additional sections regarding entities other than healthcare providers, such as businesses, with the language needed to ensure that those entities as well have the immunity from liability they need. So I will stop there and we'll be happy to take questions.
Thank you, Dr. Harris. Any questions for Dr. Harris? All right, seeing none, we appreciate your testimony. So just for clarification for the committee, what you would like to see is the language originally found in 35-114 to be restored.
Madam Chairman, yes, that is what we would suggest for healthcare providers. And if there needs to be additional clarification for businesses and other entities, but potentially just moving that to a different section and keeping the way it is for healthcare providers.
All right, thank you so much. All right, thank you, Dr. Harris. Thank you, Mr. Dirkstall and Ms. Bush. Stand by just in case we start working the bill. I need your expertise. Again, you'll just be stuck here for an hour. Appreciate everything that you're doing. All right, next up we have, looks like Ms. Delancey from the Wyoming Business Alliance. Welcome, Ms. Delancey, great to see you. Give you a minute for your video to come live. All right, looks like we might have lost her for a minute there. Ms. Delancey, if you're there, if you would start your video. And I think next up on the deck was Miss Lance, Beth Lance. If you're there, if you want to start your video, and whoever we see first, we'll hear from. All right, there's Ms. Delancey, welcome.
Thank you, Madam Chairman. Unfortunately, LSO has control over the access. So thank you to your staff for allowing me in. Briefly, my name is Cindy Delancey, and I am the president of the Wyoming Business Alliance. With me today is Mr. Brad Cave. So with your permission, Madam Chairman, I'd ask that Mr. Cave be permitted to join me so we can maybe try to knock two of your list out at one time here. But today, I bring before you, kind of the business perspective on this issue. It's wonderful to see Senator French, Senator Kolb, former county commissioners. Nice to see you again in your new official capacity. Thank you for your service to the state. As look forward to working with you in your new roles. So this topic is correct. You know, you outlined it wonderfully. We were hoping that there would be some action at the federal level as far as offering some level of business protection. It appears that that window has now closed. And so it's really up to the states to decide how we're going to address this from a policy standpoint. You've heard the testimony of Dr. Harris. We learned about these concerns yesterday. We've spent hours working on this over the summer, and I can assure you that the work that has been done to date, at no time there was ever an intent to limit, dilute, change any of the immunities protections offered to the healthcare sector. The intent of this bill was to offer businesses from being subject to frivolous lawsuits. And Senator Koss nailed it right out of the gate here. The way that the statute currently reads and the work that's been done in the past by the legislature leaves the door open for a business owner that is subject to litigation as a defendant to have to work all the way through the process to be able to come before a jury to determine what is substantial compliance, what is good faith, were your actions reasonable. Those are all things that cost an enormous amount of money, take an exorbitant amount of time to get to the heart of that matter. And what we are seeking for, which House Bill 59 affords, is the ability for the court to be able to have the procedural tools in their toolbox to be able to ferret out claims that maybe can't meet a higher standard, to be able to move forward, frivolous lawsuit versus a claim that maybe has merit by being pled with particularity and also being held to a higher burden of proof, standard of proof, I should say, meaning the clear and convincing standard that is in House Bill 59. Now, Senate File 19 does not include those subparts, so I don't mean to confuse the water, but we appreciate Senate File 19. However, the business community just doesn't feel it goes far enough. I have some amendments ready for you to create that to restore that initial language of the healthcare immunity, as well as creating a carve out for businesses. So should the committee work the bill, we have something already prepared for you to evaluate if you'd like to kind of move dealing with businesses separate from the healthcare immunity, such as Dr. Harris suggested. But this is an extremely important issue to the business community. We feel it's really incumbent upon you as our policy leaders to get this right. You all know that business has been incredibly under enormous challenges and being sucked up in a frivolous lawsuit. Whether we currently have any today or not, I believe is kind of irrelevant. We have the opportunity to take steps to protect our businesses and to give them an extra layer of ability to make sure that they don't find themselves stuck in a lawsuit trying to defend themselves as to whether or not an individual that got COVID and the worst case scenario, someone passes away, having to defend themselves in a wrongful death suit. So I know we have a lot of in the hopper. I will keep my comments brief. I just don't know if Mr. Cave has anything to add, but I do appreciate your work on this bill, and we're happy to work with you to make sure that we get this right. Again, just wanted to reiterate that there's never been any intention to dilute the immunity afforded the healthcare community.
Thank you, Ms. Delancey. We would ask that you provide those amendments to the committee. The committee does intend to work the bill and hopefully move it out this morning. The Judiciary Committee is the committee that's been tasked with this issue all along. It is the appropriate committee pursuant to the Wyoming legislature's rules, and the Judiciary Committee will take up this issue. So appreciate all the work that has been done in both committees by Mr. Cave, but we would like to see those amendments that you have in order to separate the two issues associated with healthcare providers and businesses. So if you could email that to the committee, that would be most helpful. Mr. Cave, welcome to the committee. If you'd like to introduce yourself.
Thank you, Madam Chairman. I'm Brad Cave. I'm a partner with the law firm of Holland and Hart in Cheyenne. I'm here today on behalf of the Wyoming Business Alliance. And Ms. Delancey explained the position of the Business Alliance very well, and I'll try not to plow the same ground. I would like to offer the perspective, a little more detail in the perspective of that she raised regarding litigation and the cost of litigation to business. In the litigation process, a plaintiff, a person bringing a lawsuit, can file a claim, can file a complaint in court, and can make allegations that are quite general and quite lacking in any specificity. And a judge will dismiss that complaint early only if no set of facts appear on the face of the complaint under which relief can be granted to the person who brought the lawsuit. So in the context of a COVID claim, a person could allege that that they caught COVID, that they were at a business, that they contracted the COVID at the business, and that they've suffered damages and the business is liable for those damages. And very little more than those allegations would be necessary under the traditional pleading standards to require that business to defend that lawsuit through the discovery phase, through depositions, through retaining experts, and that sort of thing, at least through that stage until they get a chance to file what's called a motion for summary judgment late in the case, or perhaps even all the way through trial. So one of the things that that we've always felt would be important in a business liability protection bill like Senate File 19 is a requirement that a lawsuit that comes forward claiming COVID liability, claiming that COVID was contracted at a business or contracted by another person from another person, that lawsuit be stated with particularity, that the allegations of exposure, the allegations of how COVID was contracted be stated with particularity, more of a who, what, when, where sort of requirement in the complaint itself, so that a party who's being sued for this has the opportunity to go to the judge and say, this is not stated with particularity. The details of how this happened are left unstated in this complaint, judge, and you should dismiss it. You should dismiss it maybe without prejudice and give the party another chance, but one way or the other, the party needs to come forward with some particular allegations. I also want to point out that this is not a get out of jail free card for every single business, no matter how they conduct their business. The original statute and this bill carve out claims that are based on gross negligence or willful and wanton misconduct. So when if a business is truly acting recklessly, if they're acting grossly negligently, this immunity will not protect that business. This immunity is intended to protect businesses that are doing their best under difficult circumstances. And finally, one of our concerns with the language in the original statute and as carried forward in Senate File 19 is the use of good faith as a standard. Good faith is one of those things like substantial compliance that is in the eye of the beholder, and determining when somebody's acting in good faith is going to be subject to arguments back and forth. It does not give a judge a clear standard by which to determine whether a business's conduct with respect to COVID-19 should entitle them to immunity. It essentially leaves that question to juries, which means that you have to go through that whole litigation process again before claims that lack merit can be addressed and dismissed, thereby sparing the business the cost and disruptions of doing so.
All right, thank you, Mr. Cave. I'm going to kind of shorten your comments a little bit in light of how many more folks we need to hear from. Questions for Mr. Cave or Ms. Delancey at this time? All right, seeing none, stay close by. We look forward to receiving that email with the proposed amendments. I believe we have Ms. Lance. Welcome, Ms. Lance. You're on mute.
Good afternoon. Thank you, Madam Chair. I'm pleased to be here to provide testimony today on behalf of the Wyoming Trial Lawyers Association regarding this bill. The trial lawyers are not in favor of this bill as it stands. Madam Chair's comments and synopsis regarding the history of COVID immunity within the state of Wyoming are well taken. There has been now already immunity passed essentially to this exact statute granting immunity to businesses and not just healthcare workers as it was previously drafted. And so that has been now the law since the special session last year. And that law is working. The immunity currently provided to businesses is clearly working when, to our knowledge, no lawsuits have actually been filed against any businesses due to contraction of COVID-19. Additionally, besides besides the fact that we don't know of any lawsuits, we also have concerns then about the concept of potentially creating an imbalance here with this bill. Certainly, it begins to get towards the side of not creating incentives for businesses to potentially act in good faith, and does add language such as substantial compliance, which I think is difficult to know what that means. And so certainly we don't want to disincentivize businesses from doing the right thing and from following the continuing public health orders for the duration of this public health crisis that we are in. Additionally, I think it's important to understand, just from a legal perspective, that such a lawsuit would be incredibly difficult to prove. I think everyone can see how would you prove where someone necessarily contracted COVID-19, whether that was even at a specific business that they went to or not. And so really, essentially, the groundwork for any slew of lawsuits isn't there. Any reasonable attorney would have a difficult time being able to bring a lawsuit on this topic just because of the difficult burden of proof that would exist. And then additionally, beyond that, there is immunity already. So we see this bill as just unnecessary. It seems to go too far in the language as to create a situation in which it would be completely impossible for a very legitimate lawsuit to potentially be brought, although I'm struggling to know what that lawsuit would be at this point in time. And again, there haven't been any, but certainly it's important, I think, that we don't go so far as to remove people's constitutional rights with creating some kind of blanket immunity situation that disallows people's constitutional rights to some type of judicial remedy if that were warranted, if there were a situation in which it was actually warranted. Again, we as an agent or as an association of attorneys are not in favor of this legislation, and we think that what already exists is sufficient. And so I would just stand for any questions.
All right, thank you, Ms. Lance. Any questions for Ms. Lance, the Wyoming Trial Lawyers Association? All right, seeing none, thank you, Ms. Lance. Stand by as well. I think we have next up on deck, Ms. Wilkinson, Catherine Wilkinson. And then also we'll get ready, Mr. Larson. Wilkinson, welcome to the Judiciary Committee. It's great to see you. If you'd introduce yourself.
Absolutely. Thank you, Madam Chairman, members of the committee. My name is Catherine Wilkinson. I'm here today representing Property and Casualty Insurance Association. And Madam Chairman, we are here today to stand in support of the bill. I do know that there are the two bills going through it, and we are committed to working both of those bills as they move through the process. But we do insure a lot of small businesses across the state, and we do want to ensure that there is adequate protection for those businesses and protection from any lawsuits that may arise out of COVID. And in the effort of being brief, Madam Chairman, we do support it, but I would stand for any questions.
All right, thank you, Ms. Wilkinson.
Thank
I
you.
would say that's the shortest testimony from a lawyer we've heard yet today. So appreciate that from the insurance industry. Thank you, Ms. Wilkinson. All right, Mr. Larson, Mark Larson.
Madam Chairman.
Madam
Chairman, we also have Josh Hands up to testify, I believe.
Oh, wonderful. Mr. Hannes, yeah, if you'd show your video, and welcome to the committee. Sorry, I missed you I have my screen, so I can't see those that don't have video active to keep it clearer for me. So sometimes I miss it when you come in. So forgive me for skipping over you. Welcome to the committee. If you would introduce yourself.
Thank you, Madam Chairman. My name is Josh Hannes, and I'm with the Wyoming Hospital Association. I will try to be brief as well and echo the thoughts that Dr. Harris presented earlier. At this point in time, our organization believes that the statute as written, specifically in 35.4.114 subsection A, as it's written today, does meet our needs and provides the protection that we are seeking. We would stand in support with our partners in the business community if if expansion of this statute is needed to provide them protections, but we believe for our purposes that the statute as written is sufficient, and we would encourage that language to remain. And I would stand for any questions.
Thank you, Mr. Hannes. Senator Cole.
Yeah, thank you, Madam Chair. Could you explain to me why the word changing would then not have you covered as a healthcare provider on page 1, lines 15 and 16, I suppose, in this case? Why would that change be detrimental to healthcare providers for coverage of liability?
Mr. Hannes?
Madam Chairman, Senator Cope. So to be perfectly honest, I'm not an attorney, and I'm not going to pretend to be one here today. This process has been a learning process, certainly for us, and through this process, we've come to the conclusion that where we are is the protection that we need.
Thank you, Mr. Hannes. Potentially, I can help kind of augment that question at this time based on my understanding, and we can hear more testimony about it. But I believe if you look at page 2, lines 7 through 10, really 6 through 10. So there's the deletion in blue of the words complying with those instructions or acting in good faith. So immunity is granted to a healthcare provider or a business entity for complying with healthcare instructions or acting in good faith in response to a healthcare to a pandemic. And that was where it ended. Now that language has been deleted, removed, and replaced with acts or omissions of the person or entity that caused another to be exposed to or contract the disease. Well, healthcare providers typically aren't causing people to contract the disease, they're treating people with the disease. So certainly there could be a cause of action associated with the healthcare provider, causing the contraction of a disease in a healthcare facility. Certainly that occurs, as we know from our long-term care facilities, that it spreads easily in there and hard to prevent. But really, what the primary concern that is now not addressed is immunity associated with the treatment plan with somebody already with COVID. Or, as you heard testimony, the latest concern over liability associated when a healthcare provider needs to make a decision over who gets the ventilator or who gets the specialized medication when there's a limited amount and too many patients. Does that help? Kind of? No? It's a good effort. We'll let the others continue moving forward, and I'll keep trying. Thanks, Senator Cole. All right, Mr. Larson. Thank you, Mr. Hannes. I appreciate you being here.
Thank you.
Thank you, Madam Chair. Can you hear me now?
We can hear you. Thank you, Mr. Larson. If you'd introduce yourself to the committee, and welcome.
Thank you, Madam Chairman. Mark Larson with the Wyoming Petroleum Marketers and Convenience Store Association. I want to thank Madam Chair for the incredible work you did in the late hours of the special session to get the bill that we supported at that time. With all due respect, the petroleum marketers and convenience stores are wanting a higher threshold. We believe that the good faith threshold is going to drag marketers and convenience stores into court when the option of clear and convincing is an available option that we would support. We are the essential businesses, some of the essential business, and I know some people don't like that term, but we remained open for people to buy gas and groceries, and we're exposed to the multiple shifting of chairs on the deck by the CDC. Accordingly, we adopted our own best practices and have promoted those with our marketers and convenience stores, and I'm hoping that most of my members follow that. We have a little bit different perspective, Madam Chair and committee members, in terms of the good faith versus the clear and convincing standard. We have felt the sting of some of the, and I don't mean to be diminutive, but the trial lawyer groups that we're seeing who are issuing demand letters on ADA and some other laws, knowing that we as business owners, and several of the members of the committee are business owners who have been conditioned by insurance companies and their own counsel to go to settlement anytime that a case is pending. And we're deeply concerned that without the clear and convincing language, that the good faith standard would require us to spend excessive dollars and compel our members and their counsel to go to settlement. We don't think that that's an acceptable condition. We have heard testimony yesterday, and I know that's not good because the committee didn't hear that testimony, but we've heard expressions of the rights of people to bring suit. We have no problem with that. If they can bring clear and convincing evidence that says that the suit is necessary, we get that. But we also need to recognize the rights of the acting good businesses that should not suffer from the abuse of frivolous lawsuits brought primarily to seek settlement. And Madam Chair, that's my testimony. The petroleum marketers respectfully would seek a higher standard, and so therefore we're opposing the bill.
Thank you, Mr. Larson. Any questions for Mr. Larson?
Thank you, committee. Thank you. Oh,
Senator Kolb.
Thank you, Madam Chair. What language changes would you suggest in this bill, if you could, or what would you bring forward to change to make it more suitable for your opinion? Thank you.
Mr. Larson.
Thank you, Madam Chair. Senator Kolb, I will definitely do that. But at this point, we do see a bill that's been worked in the process that covers our concerns, and but I will take that back to my board, and thank you for the suggestion.
Senator Cooper, did you have a question?
No, Senator Kolb addressed exactly what my question was.
Wonderful, thank you. And Mr. Larson, for clarity, you made a reference of demand letters concerning ADA compliance. And of course, neither of the bills currently in the legislature would deal with any kind of Americans with Disabilities Act kind of litigation, right?
Madam Chairman, you're right. That's correct. But we have deep concern that when we get this COVID played out and we start seeing the cases that we've seen over the years, ADA has been around for decades. We just have fear that if we don't get some coverage, that we're going to start seeing those demand letters, primarily because our members have been conditioned to move to settlement. We see it as an easy way for somebody to try to exact a position that's costing us money when we could have a different standard.
Thank you, Mr. Larson. Appreciate it.
Thank you, Madam Chair. Thank you, committee.
All right, looks like next up we have Mr. Simpson. And Mr. Simpson, I'm going to limit your comments. I'm sorry, you're last on the list to 5 minutes, and that will allow the committee 20 minutes only to work the bill. So if you could even be briefer than that, that would be most helpful. So
thank you.
Please introduce yourself to the committee and welcome.
Thank you very much, Madam Chairman. I'm Colin Simpson. I am a past president of the Wyoming Trial Lawyers Association and have been practicing law again full time since I left the legislature in 2010. And I represent many injured people. And the trial lawyers have about 325 attorneys around the state who represent the rights of injured people. I would like to back up just a little bit and talk about Senate Enrolled Act number 2 that was passed. And the chairman raised the issue of the changes to the workers' comp law. Just so you're aware, committee, a person under the law as it stood, an illness or communicable disease was not necessarily defined as an injury. The legislature changed that definition and added this language. that for really 2020, if any employee in any employment sector for which coverage is provided by this act is infected with COVID-19, it shall be presumed that the risk of contracting the illness or disease was increased by the nature of the employment. That means the presumption is in favor of the employee that they got it at the employment. Now, what these bills want to do is take any presumption away, or not even give an injured person the right to challenge the fact that they may have received COVID at some business, even though there is currently immunity already on the books. So you give employees greater rights, but you take away the rights of the average citizen who isn't employed in that facility. That's one thing that I think you should consider. It seems quite a dichotomy today. And I thought the chairman's explanation of those issues about on page 2, lines 6 through 10 was why the healthcare community is against the bill as it's written. I would suggest to you that this bill does nothing but confuse the issue. The existing language is fine. You don't need to add substantial compliance. Substantial is a question of fact for a fact finder. You already have two things in there that if they act in good faith and they follow the instructions of a state, city, town, or county health officer, they're immune. And most lawyers who are going to look at any type of case are going to read, wow, they're immune if they acted in good faith. How could I possibly show they didn't act in good faith? That's a pretty high bar right there. So you already have the immunity. What the some members of the business community want is as near absolute immunity as they can get. And in my experience in the legislature, many people come to you and ask for immunity for a variety of different reasons. And you have to be very careful when you're analyzing the rights and you're balancing the rights of your constituents versus their right to seek fair compensation versus having no right at all. And the amendments that are going to be proposed to you that are in House Bill 59 are substantial. And they change the burden of proof and the standard of proof, and they're significant. And we don't think that they're needed whatsoever because the existing language itself is there. One of the comments was made that the whether we have any lawsuits today is kind of irrelevant. I would absolutely disagree with that. You are trying to weigh the risk versus the benefit. So what is the risk? If there are no lawsuits, and we've been in the pandemic for 10 months at least, I'm not saying there won't be, but you already have an immunity bill. Do you really need to monkey with the legal standards in a civil negligence case when you're granting immunity? And I think that the risk of taking away people's rights is not outweighed by the risk of granting immunity. I mean, the risk of a lawsuit. And I mean, I don't, in my experience, if I send a demand letter, I don't see people just saying, oh, sure, here's some money, we'll go away. That's not the way it works. Yeah, this is a system and a process. And to change those standards and burdens of proof is something that you really have to consider strongly. And I would urge you not to, and not do anything with Senate File 19 and just leave the statute as it is. Thank you, Madam Chairman, members of the committee.
Thank you, Mr. Simpson. Thank you for your service in the legislature. Any questions for Mr. Simpson? All right, thank you so much.
Thank you very much. Have a good day, everybody.
All right, committee, back to you. I don't see any additional public comment. Ms. Creech, is that correct?
Madam Chair, that's correct.
All right, wonderful. I want to thank everyone who provided public testimony so quickly and so efficiently in respect for the committee's time. Again, I've asked you all to stay close to see just what we might address here this morning. So thank you, committee. one last push here to focus in. We have 20 minutes left to get some final work done on a pretty substantial bill. I am hopeful we can get this bill out of committee with some of those amendments. Committee members, you have received the proposed amendment from the Business Alliance in your inbox and from Ms. Creech. Do all of you have that? If so, nod your heads yes. Yeah, I guess I should need to look at the screen for that to occur. Wonderful. Give you a minute to study those amendments. All right, committee, we are back on this bill, and right now what I need is a motion on the bill. Moved by Senator Cost. Is there a second on the bill? Senator Cooper, thank you. Looking for any amendments on the bill. Is there an amendment on the bill? Senator Cost, I'll give you a minute there to get a drink of water. There is an amendment. Are you going to move the amendment proposed by the Business Alliance?
Madam Chair, yes, I would move the amendments proposed by Business Alliance be considered.
All right, and so those potential amendments are on page 1, line 14. Subsection A should be revised to subsection D. On page 2, line 19. Subsection D should be revised to subsection E. And page 2 to line 19, the reference to subsection A should be changed to, quote, in this section to apply to the entire statute. That's so the public can track what we're doing. I'll give the committee a minute to track that in. Do you want me to read that again when you see it, Senator Cost? Yes.
Madam Chair, I just received a note from Ms. Delinsky that on page 2, line 17, we might want to consider something. Do you want that as a separate amendment?
Why don't we do that? Yes, a separate amendment.
Okay, thank you.
So on this first amendment, is there a second on Senator Cost's amendment? Seconded by Senator Kolb. So discussion on that amendment, and again, give you an opportunity to track that in. Okay, any discussion on the amendment? Are you prepared to vote? Okay, committee, all those in favor of Senator Cost's amendment, please raise your hand. Okay, that's a unanimous vote. That motion has passed. Senator Cost, do you have a second amendment?
Yes, Madam Chair. On page 2, line 17, add a comma, and then, and the allegations of any action must be stated with particularity and be proven by clear and convincing evidence.
All right, is there a second on that motion? Seconded by Senator Kolb. Discussion on the amendment. Senator Cooper.
How necessary is that? As Mr. Simpson stated, we've already provided immunity, and I'm just not sure that that's 100% necessary. Thank you.
Further comments? I do anticipate this bill to be heavily amended moving forward. So just put that word of caution out there as well. But I do hope to get it out of committee. So committee, I'm going to call question on Senator Koss' motion to add the changing standard for clear and convincing evidence. Please raise your hand. That motion has passed. Any further amendments on the bill? Ms. Creech, are you tracking along okay?
Yes, Madam Chair, thank you.
Thank you. All right. Seeing no further amendments, committee, are you ready to do a roll call vote on the bill? All right. Roll call vote.
This is a roll call vote on Senate File 19. Senator Cooper.
Aye.
Senator French.
Aye.
Senator Kolb.
Aye.
Senator Cost.
Aye.
Chairman Nethercott.
Aye.
That passes unanimously.
All right. Thank you, committee. Thank you, members of the public, for your participation. I know this is a frustrating process concerning this immunity bill. I know it's been painstaking and painful. We're going to continue to work these bills and work these issues and make sure that we're able to strike the right balance, protecting our healthcare providers and healthcare institutions in a time of crisis, protecting our businesses as they have the courage to reopen and continue to provide services to our constituents, and also to ensure that we are true and provide fidelity to our Constitution and the people of the state who might need a judicial remedy. So we'll continue to balance those three interests as we have always done, and we'll continue to do. Thank you, everyone, for your participation. Committee members, a couple of things we need to go back and do before our time is up here with the last 10 minutes. Your first actions as senators, Senators Cooper, French, and Kolb, excellent job this morning. You have worked incredibly hard. And this is what it looks like. It gets this messy, but we really do work through. As you can imagine, if we had a full day of committee meetings, we'd be going for another 4, 5, 6 hours and then do it again the next day. So it gets pretty exhausting. One thing that I failed to do to want to make sure to go back and we talk about who will be taking up these bills to present in the event we do this in the 10-day Zoom meeting coming up or in March. So we have Senator French taking Senate File 5. We have Senator Cooper taking Senate File 21. And Senator Cooper, I'll help you with that, but it's a pretty easy lift on that one. Electronic court filings. I wouldn't dare give that to anyone else but myself. Bless you all. So I'll take that one up. Senator Cost, you can take Senate File 23 as you're familiar with that bill, having run it in the past, and that's the public meetings for executive sessions for security plans. We have voted to table Senate File 6 to deal with again and take up in the March session. And so kind of remember those conversations, go back to your constituents and stakeholders and understand some of those issues more thoughtfully, and hopefully we can work out some amendments to address those concerns, but we'll work that bill again in March. And so Senate File 19, I, of course, will take this bill as well and wouldn't make you suffer through that. So Senator Kolb, you survived this one. So that leaves Senate File 20. For members of the public who care about that bill, we care about it too, and we will hear it in March when we meet again and the Judiciary Committee continues to work. As a result of our time restraints today, best to just let that bill be heard in March. So it's not going away, it's not disappeared. We'll still have the ability to address it in a few weeks, so not to worry. Committee members, any final thoughts or questions? Yeah, Senator French.
Yeah, Madam Chair. Wow, I should have put a sweatband on. I mean, no, it was great. Great learning experience, and that's all I got to say.
Yeah, it's intense. It's taking a drink of water from a fire hydrant for sure. And I know it's less than ideal to do it here on Zoom, but you know, I did my first meeting and first actions in at a side room of an old Kmart. So that was my that was my wonderful experience from the Jonah building as the Capitol was under construction. So soon we will get back to business and understand what it's like to really do this work in the people's house. So appreciate your patience and understanding as we work through this. Again, great job, committee. Thank you, LSO. You've done a brilliant job of getting all of those participants in. Any final comments from you, Ms. Creech?
No, Madam Chairman, thank you so much.
All right, everyone, have a great day. We'll see you soon. Meeting adjourned.